Yes,
May I
Mr.
please, Your Lordship?
Yes,
Lord, in regard to item 49,
39.
44.9, my lord.
Yes.
In regard to this case, my lord, I have another matter in court number 14. That is item number 2. But
Court-
the record is here, my lord. So can I, these are analogous. case,
Court
my lord.
number 14.
14 and item number 2, the motion item is there, but the record is here.
So what is to be done? I mean, that's a senior bench, I think 14. 14
Yes,
is a
that
senior
what
bench.
I was thinking that if this case can be transferred there, then we can do the case and since the record is there, the court can get the help of the record.
Record is here.
Yes.
Along with item number, sir.
49, 49.
14.
If it is possible.
Then we will transfer the matter along with the
Along with
record.
the case record.
Along with the, it's from the same FIR, right?
Same affair.
Same FIR. Right. Heard Mr. S. Datta, the learned senior counsel, appearing for the accused applicant. Full stop. He submits that another analogous matter arising out of the same FIR, that is bail application number,
That is, my lord,
bail or AB?
37, bail application,
Bail application number
372 of 2026.
and is listed before court number 14. Court number 14 of this court today. That is on 10/2/2026. He submits that the records of the of both records of this records of the aforesaid bail application, which is the same for AB number 2873/2025 is available before this court. He submits that this matter, that this AB application can be transferred. Okay, AB application along with the case records can be transferred to court number 14 so that both the matters can be heard together. The prayer is allowed, let the instant AB application along with the records be transferred to court number 14 for consideration of the aforesaid two applications together. You transferred?
May I please, Your Lord, sir? I beg to mention item number 36, my lord.
Yes.
From orders column, my lord. This may be taken after a week, my lord.
Hmm?
After a week. my lord.
36.
Yes, my lord.
Records call for records received today, Malad. Will go from any other paper?
Okay, he's asking for, we heard Mr. D. Bora, the learned counsel, appearing for the applicant. Full stop. He prays for adjournment of the matter for a week.
My lord.
Let the matter be listed after a week.
May it please, Your Lordship. I beg to mention item number 41 and 42.
41,
42.
yes.
The matter may be kindly adjourned for the day.
Why?
Any day, Your Lordship, is it after 2 weeks?
Hmm?
2 weeks. Lordship.
No, why it's a old matter, 2018 matter.
Because AM1 is out of session and we have already given it, given the.
Sleep you have given
Yes,
yesterday.
yes, no, before yesterday.
Hmm?
Before yesterday.
And
It's
you have
already
given-
mentioned in the cause list that AM1 is in need.
Okay, he's on leave.
Yes.
Okay. You are Mr.
MS Hussain.
Mr. M.S. Hussain, learned counsel, appearing for the petitioner, submits that the leading counsel in the instant case, Mr. A.M. Bora, senior counsel, is out of station. They have praised for adjournment of the matter for
2 weeks, Lordship.
adjournment of the matter for 2 weeks. Prayer is allowed. Let the matter be listed after 2 weeks.
What should be an interim? The interim-
41 and 42.
interim may continue.
Interim order so passed earlier shall continue till the next date of listing.
May I please, your lordship? Lordship, I beg to mention item number 50 supply list, lordship.
50.
Yes, lordship. Lordship, in the same matter, lordship, division bench, court number 4, item 11 wrongly listed, lordship, and in this court also listed, lordship. Lordship, my senior M. Kumari, for the respondent who appear, lordship. Today we are not fully prepared, lordship.
Have you intimated the counsel of the other side? Have you
No,
intimated
lordship.
Mr. B.M. Chaudhary?
Lordship.
Then you should have intimated him. Without intimation, how will you wait for your turn?
Obliged, lordship.
You should have intimated.
May it please the lordship. My lord, I beg to mention item number 29, my lord. 29.
29, yes.
My lord, to my understanding, the CD is not there in this case, my lord.
Item number 29, you write.
I am on interim, my lord. That interim may be continued.
29, you write.
So
Heard
AB,
Mr. Your
AB there, my lord.
every day.
Yes, my lord.
Heard Mr. A.B. Day, learned counsel appearing for the accused applicant. Submits that CD in the instant case is yet to be received. Full stop. Let the matter be listed
On the 6th of March,
on 6th March
My lord, can
2026.
it be on second of
second.
Let it be listed on 2nd of March.
deeply obliged.
Maybe.
Yes.
I beg to mention item number 25, Lordship.
25.
Lordship, in
Yes.
this case, Lordship, TCR was called for. That has not been received, Lordship.
Okay, learned, Mr. So-and-so, learned counsel appearing for the accused applicant submits the TCR in the instant case is yet to be received. Let the matter be listed. after
On
2
Monday,
weeks.
Lordship, next Monday. On 16, Lord.
Let the matter be listed on 17th.
All right.
17th.
Okay.
May I please, your lordship? I beg to mention item number 30, lordship.
Item number
30, lordship.
30, yes.
CD not received, lordship.
CD not received.
I'm on in time. Please-
30 is one of them.
You heard me, MS so-and-so, the learned counsel appearing for the accused applicant, submits that the CD in the instant case is yet to be received. Let them, let the matter be listed after, when?
That means they are on 6th of March.
Let the matter be listed on 6th of March.
Lordship, kindly
Interim order so passed earlier shall continue
can
till the
it be,
next date of listing.
After or before 6th of March?
Okay.
After?
10th,
After?
After or before 6th of March?
10th of March.
Okay, 10th of March.
Obliged.
Heard Mr. So-and-so, the learned, your SH Mahmood. Heard Mr. SH Mahmood, learned counsel for the accused applicant. Also heard Mr. K. Parashar, learned APP for the state. Mr. SH Mahmood, the learned counsel, submits that he desires to, on instruction, he desires to withdraw the instant application. Prayer is allowed, the matter is dismissed as withdrawn,
Please, your lordship, I have instruction to withdraw this petition.
The heard me MS so-and-so, the same order, huh? Withdrawn.
My lord, here, my lord, I am praying for, call for the scan copy of LCR, my lord. Case is registered under commercial quantity of NDPS Act, my lord.
Okay, heard Mr. So-and-so. This is an application, you write, huh? Charge sheet filed or?
Rashid file trial is going on, my lord. I am
Okay.
on the ground of my lord, notice, ground of arrest is not there, my lord. The notice and arrest memo, my lord.
Okay, raised to call for. the TCR in the instant case. TCR of the case, special case number 520/2024 corresponding to Gauripur PS case number 118/2024 from the Court of Learned Special Judge Dhubri. Let the case be listed on
20, Lordship, 20.
20th of February, 28th of February.
Lordship, the regular bailiff will shown, Bongaigaon PS case number, D18/2025 under section 140 subsection 3 BNS, added section 64, subsection 1 BNS, related to section, POXO. Four. POXO is there, in the
Noted.
system, kindly call for CD. And the notice may issue to respond.
Heard Mr. So-and-so, learned counsel appearing for the petitioner, accused applicant, also heard MS and thus the learned APP for the state. This is an application you write, huh, on this? Let notice be issued on respondent number 2 through the registry as per the prevailing notification of issued by the issued by Gauhati High Court. Notice to respondent number 1 is dispensed with as the learned APP enters appearance on behalf of the state. Call for a CD. Let the matter be listed on
19, Lordship.
19th. 19 to 2026.
Charge sheeted matter, my lord, trial court record reports.
Heard Mr. H.R. Chaudhary, the learned counsel appearing for the accused applicant, also heard MS and thus learned APP for the state. Here is an application under, you write those, registry to call for the TCR, scan copy of the TCR. TCR of special NDPS case number 69/2025 from the Court of Additional Session Judge Sri Bhumi.
On 23rd.
Let the matter be fixed on 25th to 2026.
Please, your lordship, lordship, kindly may matter pass off for timing, your
Lordship,
lordship.
POXO Act is there, Lordship, notice, Lordship.
Lordship, let him come, your lordship. Engaged counsel is in legs also. Engaged counsel is legs
Who
only.
is engaged counsel?
R. Burwa, lordship.
Huh?
R. Burwa.
R. Bora, full name?
Ritupurna Burwa, your lordship.
And this is a, a matter relating to POXO, isn't it?
Yes, Lordship,
I
section
don't
6
know,
of,
I'm not connected with it, no, with him, your lordship. He's my colleague. Just
Okay, we'll
timing.
wait for some time.
Right.
Password for time being.
Thank you, Lordship. Lordship, POXO matter, Lordship. At this stage, notice will be issued.
Heard Mr. So-and-so, so-and-so. This is an application so-and-so.
TCR may be called for.
Let notice be issued on respondent number 2. Right. Notice to respondent number 1 is dispensed with. Leave then. Then. Is charge that matter?
Lordship.
yes, Lordship.
Call registry to call for the TCR in connection with POXO case number 129/2024 from the Court of Learned Additional District and Session Judge, come Special Judge, POXO Morigaon. Let the matter be fixed on
24th, Lordship.
24 to 2026.
May it please, Lordship, madam?
Yes,
Regular bail application, madam. Here it is, here, my lord, although charge sheet has been submitted, my lord,
Hmm.
on the same facts and circumstances, my lord.
Hmm.
4 persons were arrested, my lord. 2 have been granted the privilege of bail, my lord. So I would like to.
So we'll call for this and we'll put a short date.
I leave it to your lordship. Only thing here, my lord, statement of co-accused, my lord, the prime accused, he implicated the other person.
But what, I mean, what offense?
No, offense is, my lord, murder and rape, but, my lord, he has confessed before the police that he has done it, my lord.
Okay, we'll give you a short date and.
Then, my lord, can I pray one thing, my lord? Lordship, here, my lord, the other 2 orders we have annexed, my lord. Lordship, kindly have a look, page 85 and 88, my lord.
Man, he's the, I mean, how he's implicated?
Same, my lord. The main accused, my lord, the
Hmm.
person who confessed before the police,
Hmm.
he gave the name of 4 other persons.
Hmm.
Out of the 4, 2 granted bail.
Hmm.
These 2 orders, my lord, page 85 and 88. And they were granted bail. Kindly have a look at page 86 once, my lord.
86.
86, my lord. Here, lordship, find, my lord, upon perusing the charge sheet, we have another charge sheet here, my lord. I find that as many as 43 witnesses are listed there. Though charges have been framed, but considering the number of prosecution witness and the fact that the first date of prosecution evidence is fixed on so and so 16/2, the process of trial would take a while. Thereafter, my lord, considering the stage of the case and considerable length of pre-trial detention, my lord. So here also same date of arrest, my lord.
When?
It is, my lord, they're in custody from 16/8. That is around nearly 6 months, my lord, in custody, my lord. Around 178 days. This is one order. And the next order, lordship, kindly have a look at, it starts from page 88, my lord. There also, lordship, find page 89, my lord. Here, my lord, page 89, my lord. And that para 9, my lord.
But here, lower court has granted bail, then, I mean, again, you surrendered, what happened?
That is other person.
Other person, why, what?
But he, for some, my lord, emergency situation, he was granted, my lord, other co-accused, so he again surrendered, my lord. But date of arrest is same, my lord. In fact, he was arrested on the next day, on 17th, my lord. But so far, this accused is concerned, my lord, on the same, that is 15th, my lord, that what should find page 89, my lord, 15/8/2025, same date of arrest, my lord, and the forwarding report also we have annexed, my lord. Same date of arrest, my lord, and same implication, my lord.
Lordship, order copies are not annexed with this petition, Lordship.
Where is their FIR?
FIR, my lord, lordship, find, my lord. That is, we have annexed page 16, my lord.
Page 16.
Lordship. Here, my lord. One, the mother of the informant, my lord, she was missing, my lord. From, my lord, 13/8/2025 evening, my lord. So this FIR was lost by the son, my lord, against unknown person, my lord. Thereafter, my lord, would kindly have a look. Page 16 is the FIR, my lord.
Record may be called for, Lordship.
Now, first step, unknown person, my lord. It was lost on 14, my lord. There
I will see I mean, similar circumstances, the coordinate bench is allowed after perusing the TCR. So I don't think we should keep this pending for the TCR. Heard Mr. E. Chaudhary, the learned, A. Chaudhary, the learned counsel appearing for the accused applicant. Also heard Ms. N. Das, the learned APP for the state. This is an application on the so-and-so, right? Application on the. And so. The case arose out of an FIR lodged by the son of the deceased with the allegation that some unknown miscreants have killed his mother. The petitioner was, next paragraph, the accused applicant was arrested and in judicial custody since 15/8/2025, right?
My lord.
15/8/2025.
16, my lord.
16/8/2025. 16/8/2025. Full stop. The case has already been charge sheeted and registered as special case number
4 of the
special sessions in bracket special case number 4/2025 under section 103 in bracket 1/70 in bracket 1/3 bracket 5/16 in bracket 2 small a of BNS 2023 read with section 3 in bracket 2 in bracket small 5 Roman 5/3 to bracket Roman 5 small a of the scheduled caste and scheduled tribes in bracket Prevention of Atrocities Act 1989. And added section 3 in bracket 5/61 in bracket 2 bracket small a of BNS 2023. The learned counsel appearing for the accused applicant has submitted that the two co-accused arising out of the same FIR has already been granted bail by a coordinate bench of this court after perusal of the trial court records. He submits that since the present applicant is also similarly situated and has been arrested at the same time, he should be also granted bail in the instant case. He has submitted that the prosecution evidence has not yet started so far. And since as many as 43 witnesses are listed in the charge sheet, though the charges have been framed, considering the number of prosecution witnesses and the fact that the first date for prosecution evidence is fixed on 16/2/2025 and 2026, the process of trial would take some time. And therefore, at this stage, how many days we have spent?
No. 178 days,
hmm?
to be precise, 178 days.
Since he has already spent 178 days pre-trial, no, so many days waiting for the trial, he may be granted bail at this stage. The learned APP appearing for the state, however, submits that that trial court records should be called, and after perusal of the trial court's records only, the bail should be considered in the instant case. This court has heard the submissions made by the counsel appearing for the respective parties, and after considering the stage of the case and considerable length of pre-trial detention that has already undergone by the accused applicant till date, as well as considering the fact that two of the co-accused who are similarly situated with the present applicant have already been granted bail by a coordinate bench of this court. This court is of the considered opinion that the petitioner can be granted bail at this stage with certain conditions to be followed by him after his bail is granted. Full stop. Accordingly, the accused applicant is directed to be released forthwith in connection with session case number. You just write those, huh? Case number so and so, on furnishing of a bail bond of rupees 50,000 with one suitable surety of like nature to the satisfaction of the learned court of session judge, Dima Hasao Haflong. Dima Hasao Haflong. Subject to the following conditions. You put those conditions, some 3 conditions you put. Then you may write violation of next paragraph, violation or breach of any of the aforesaid conditions shall entail cancellation of the bail. In view of the aforesaid directions, the instant bail application is disposed of as allowed.
Right, please, your lordship. Your lordship, 127 days behind the bars, he was shown arrest in NDPS intermediate quantity. Thereafter, your lordship, in the charge sheet 27A was attracted, for which the default bail period of 60 days has surpassed, and there is no such material in the charge sheet even.
No, we'll
Charge
call
sheet-
for the record.
Charge sheet is page number 20.
Charge sheet is
Matter, your lordship.
Okay, heard Mr. So-and-so, the learned counsel appearing for the accused applicant, also heard Mr. So-and-so. This is an application under so-and-so, you right? Registry to call for the TCR in the TCR in connection with special NDPS case number 74 of 2025 from the court of special judge Hojai. Let the matter be listed on
23rd, sir.
Your lordship, any date before 20 or 20th even, your lordship, any date, next week. Any date.
20.
Leave your-
Whenever court gives you some time, you always have a problem with that date. Why? I think most of your cases.
Case diary will be called for, NDPS commercial body.
Heard Mr. S. Nawaz, the learned counsel appearing for the accused applicant, also heard N. Das, the learned APP for the state. This is an application under so-and-so, so-and-so. So-and-so. The case relates to how much quantity?
200 and
The case relates to recovery of
279.1 grams of suspected weight.
Like that. Then call for the case diary. And let the matter be fixed on
On Lordship 23rd.
23rd.
I'm deeply obliged, my lord. 11.
Lordship, this is a substitute matter, Lordship, and inter alia under section 18 of POCSO Act, Lordship.
Also,
Yes, Lordship.
heard Mr. D. Das, the learned counsel, appearing for the accused applicant. Also heard MS N. Das, the learned APP for the state. This is an application on the, right, an application on the so and so. Let notice be issued on respondent number 2 through the registry as per the prevailing notification issued by the Gauhati High Court. Notice to respondent number 1 is dispensed with as the learned APP enters her appearance. For respondent number 2. The charge sheet that matter,
Substitute matter.
registry to call for the TCR along with the case diary. Scan copy of the TCR along with the case diary in connection with sessions in bracket special stroke special bracket P case number 229/2025 from the court of the special judge POCSO, Lakhimpur, not Lakhimpur. Let the matter be fixed on
24th.
24th.
I have additional prayer, Lordship. There is a cross FIR. So that case diary of that case may also be called for, Lordship. Not Lakhimpur, yes, case number 418. 418 of 25. Present case arises out of Not Lakhimpur PS case number 417. And there is a cross FIR. Not Lakhimpur PS case number 418, 2025.
You just write that the learned counsel appearing for the learned counsel submits that a cross affair has also been filed in the instant case. White number give.
Not Lakhimpur PS case number 418 of stroke 2025.
Therefore, he prays for calling the records. He prays for calling of the records of the aforesaid or aforesaid case.
In that case, the only case there, Lordship, not
Only
yes,
case
Lordship.
in case the case diary the case diary to be produced. Case diary is called for and to be produced on the next date.
Oh,
Then 44 and 21.
Again, again. 44 in-
Lordship, at the time of bail hearing, item 44, it is
21 minus.
I have been. I have 45 also a connected matter also.
So we'll take up both the matters together.
Also the 45 also a connected matter also.
45.
44, 45 and 21. That is the same file also.
So this three matters will have, will take when the bail hearing will be taken up.
So the allegation is that lots of during communal clash between the Karbi community and Bihari community in West Karbi Anglong, which had taken place on 22nd and 23rd of December, the petitioner herein had made certain slogans against the Karbi community. The petitioner herein had made certain slogans against the Karbi community. That is the allegation herein. That your lordship will find the FIR at page 14. In the first FIR, the petitioner has not been named, but subsequently the two organizations, they filed another FIR wherein 3 persons were named, which includes the petitioner.
Staying in the northeastern part, you say the local people as Chinese.
Which I understand, but there were thousands of persons who were protesting.
Karbi Chinese Gobar.
We'll see what is there in the case diary.
Lordship,
Heard Mr. R. Bora, right?
Lordship.
R. Bora, the learned counsel appearing of the accused applicant. Also heard Mr. MS N. Das, learned APP for the state. This is an application under so and so. call for the, call for the case diary. Date the matter is fixed on
25th, Lordship.
25th.
Alright. Lordship, I beg your pardon. In item number 5, my friend just pass over. In item number 5.
Item number
just
5.
Pass over for time being.
Timing, Lordship.
I was in court number 8, Lordship.
POCSO matter.
It's a POCSO matter, Lordship. May issue notice and call for the scan copy of the.
Okay, heard Mr. R. Bora, learned counsel appearing for the accused applicant. Also heard so and so. Reason application under write those, then raise it to
Hardly, very, very. Hardly, very, very.
This is my case, my lord. This is one case, my lord, whose history makes it a special case. The reason is, my lord, this is, initially this case was registered, my lord, in the year 1994. Now, my lord, the reason why I'm here is based on the order passed by this honorable court. My lord, on 7th of February 2025, the trial was to commence again.
no, who passed the order?
My lord, Justice Khawd.
No, special court passed the order. Which court? Which court has passed the order?
My lord, we had come up before this court. Initially.
No, where is the order? Where is
My
the?
lord, may I take you? Just give me 2 minutes time because I need to place the backdrop.
No, you tell me where is the order?
My lord, the order of Justice Khawd.
Precisely that, madam.
My lord, I would once take your lordship to page number 38. That's the initial order of Justice Arundev Chaudhary. My lord, this was passed, my lord. The reason why I'm here now today is, my lord, that since the subsequent order was of Justice Khawd, who has finally disposed of the matter. My lord, page 38, if I may place before your lordship. At least your lordship will get a look into the backdrop of the
Place
case.
38.
38.
Yes.
Now, my lord,
Wha-
this is the
just-
revisional
just-
application we had filed.
Just a moment.
Yes.
Yes.
My lord, may I just read out, my lord?
Yes.
It's a short order, my lord. My lord, I'm starting from the second paragraph. The
Mhm.
basic grievance raised is that there is no original record to proceed against the accused petitioner, and admittedly, the original record has been lost by the CBI. It is also an admitted position that there is no original copies connected with the investigation, and the CBI is reconstructing the case record. The BA number such and such is filed for release of the petitioner who has been in custody since 28th of September 2022. And the file has not been reconstructed and the petitioner is behind bars without trial in absence of record, in as much as there is no court record, and court records were stated or created only when the petitioner was arrested and produced on the strength of NBWA.
Hmm.
Now, my lord, as we move forth, my lord, let us come to this. So this is what was the situation. This situation remains unaltered.
No, you carry on reading.
Man. The IA is filed selling the order dated 5th of October 2023, whereby the learned special judge below has added additional charge under section 178A, 174A of the Indian Penal Code, in as much as, according to the learned code below, there is a delay in prosecution for 18 years for the reason that the petitioner has been absconding. The revisional petition was extensively heard by this court on 22nd of September 2023, 8th of September 2023. However, on 22nd of September 2023, a time was granted to the CBI to file objections in the case. However, no objection is filed pursuant to the order dated 22nd of September 2023. In the meantime, the CBI has filed this aforesaid application for addition of charge, which was allowed. It is an admitted position reflected in the order dated 28th of September 2023. The case record are not traceable in the court. It is also discernible from the order dated 17th of May 2023 that the original record of
Okay, I got it. Now what happened? See, like, this application was filed basically for adding of one of the,
Well, may I just give a
No.
bullet point of the background?
one of the, this, yeah, now then, Then what happened?
My lord, may I
Hmm.
just say?
Hmm.
My lord, kindly allows me 2 minutes time. I'll just give the bullet points with respect to the backdrop. My lord, 1994, an original case starts.
Hmm.
There, my lord, the truck was apprehended along with the driver and the khalasi.
Hmm.
My lord, before the seizure list could be prepared, my lord, both these two had rather handyman and the driver. Both of them had gone away. Thereafter, after a day from the date of seizure, my lord, a case was registered. That case ended up because they could not actually find out anything. But the court below felt that this is a ripe situation where an investigation by the CBI is required. So 1999 RC case started. Now, my lord, 2000 was the date when the charge sheet was filed. Now, from there, if we start, what happens here? How is it that the petitioner before your lordship comes in? The reason is, my lord, the truck was initially from the showroom, the truck was purchased by the petitioner before your lordship. My lord, that was in the year 1980. After that, he had sold it out. And my lord, when this truck was seized, he was nowhere in the picture. However, from the number, they traced down, they went to the manufacturer, found out who was the initial one, and then there was the thing that yes, since he was the first purchaser, it is the person should be added in the thing. My lord, thereafter a bail application was moved, which was allowed, but my lord, due to erroneous recording, my lord, there was a non-mention of the entirety of the section. So that went up before the Apex Court. Apex Court held that no, this was not considered, so it was sent back. In the meantime, trial was on. 12 witnesses were over, the petitioner was there, and he was facing the trial. My lord, thereafter, my lord, everything came to a stall. And because it came to a stall, my lord, this petitioner who was otherwise in bail and was also attending, he actually went for a penance. He went into frustration, and it's a fact, my lord, he was serving in the temple for a quite handful time of time. Now, my lord, what happened here? We came up here because when he was arrested and brought here, there was no case room. Time and again, my lord, bail petition was filed before that court, but since there was no record, actually court could not proceed. So we came up before this court to bring it to the notice that in the event there is no record, then in that event, this entirety of the trial would be mere abuse of the process of court. So we claim that either there should be a direction for expedite disposal, or my lord, there should be a quashment based on whatever is available from the TCR. Now, my lord,
No, but this 1610 order, 1610 to 2023 order specifically talks about a IA criminal was filed, assailing the order, adding of charges. I mean, that is your addition case. I mean, additional case that the case record is not there.
no, that was my
That-
primary case.
No,
for
that,
first
no, see, like what is there on the record, I'll go by that, okay? So see, this paragraph says that for this page 38,
Hmm.
bottom paragraph,
Well, kindly comes to the first paragraph, your lordship will get. Because this revision was pending. During this pendency of the revisional application, they had added the charge.
correct, that's what I'm saying, that's what I'm saying. I mean, I'm precisely saying that only. So you came before this court,
So there was a stay. Well,
stay.
getting into the 174A now.
Hmm,
But
then-
what I'm on is with respect to the initial one.
Hmm.
That is the criminal revision.
No, no,
Well,
let me understand let me understand the case, madam. You have studied the case the whole day probably. I haven't studied your case the whole day. So like, let me understand it. So what happened after that? You just tell me that.
Well, and after that, this criminal revision was heard out,
Hmm.
and the documents which was produced, that is page 41, your lordship will find. Criminal revision petition.
Correct. So what was the order passed in criminal revision?
My lord, kindly turns, everything was taken in consideration,
Hmm.
and my lord, we come down to the last phase of it.
Hmm. So where
My
is the
lord,
where is the operative part of this order? Page.
My lord, page 67 is the last portion, page paragraph 68. In terms of the above observation, the criminal revision petition stands dismissed, and the order dated 16/10/2023, whereby the impugn order dated 5/10/2023 passed by the learned special court such and such stands cancelled. A revision stand disposed of. So, my lord, there was a direction
Hmm.
that this is something, and just the paragraph before, my lord, thereby the petition is dismissed with a direction to the learned court.
Hmm.
I'm reading from the last part of the paragraph 67. That's
Yes.
in the same page.
Yes,
internal
yes,
page
yes,
67.
yes, yes.
Thereby, the petition is dismissed with the direction to the learned trial court to expedite the trial of CR number 6 of 1996 arising out of GR case number such and such, Stagepur Police Station case number
Correct,
such
correct,
and
correct.
such.
After that, what happened?
After that,
Hmm.
the trial starts.
Hmm.
My lord, I take your lordship
Hmm.
to the, there was only one witness who could be examined.
Okay.
And my lord, that's at page 92 of your lordship's page.
Hmm. You're right.
My lord, this is the entirety which has come up. And thereafter, nothing. It's 1 year again has passed by.
Hmm.
Because this order which was passed,
Hmm.
disposing and the criminal revisional application.
So it started one PW was examined and thereafter nothing happened.
My lord, no, nothing more. No further witness has come up. And my lord, this also turned hostile,
So now you are coming before this court seeking bail
seeking bail.
because you were inside the, behind the bars for?
My lord, after arrest on my lord 28th of September 2022,
28th of September
22.
22.
And from the date of the order, it's another year has passed by. Because the order was passed on 7th of February 2025.
Order for the.
Yes,
trial.
the revisional, which I just placed before your lordship
Correct,
at
correct,
page
correct. 1 year already passed for that.
And if we take the tenure which he had suffered before, my lord, he was absconding.
Hmm.
That is again, my lord, another 483 days. That's prior.
483 days prior to?
Prior to the subsequent arrest, which took place, my lord, on 26/9/2022. He was taken in custody and produced on 28th. Initially, he was arrested on 27th.
Have you given the dates? Yeah,
Yes.
is there any list or something like that?
Yes. Yes, my lord, just one moment. I'm taking your lordship to the bail petition.
Yes, it is there. It is there. It is there at page 11, 12, right?
Yes,
Okay.
total period in custody.
Mhm. So primarily your case is that, your case is not progressing. You have already spent so many, so much of time prior to this and after this also. Correct?
It's almost 4 years and
So
months now. Your lordship may put any stringent condition, whatever, and we are ready to face the trial.
you're placing some cases. Judicial pronouncements from the apex court or some other courts?
We have brought some cases. There is one
Hmm.
latest judgment also. Well, maybe I'll compile it.
It's on which points? Long incarceration or what?
My lord, page 22 to 23 is. My lord, I'm handing over a compilation. I have just marked the paragraphs for your lordship.
Hmm.
My lord, the last is my lord SCC, which I'm relying on.
The first one is on which point, which ratio that you are placing?
My lord, may I just? I'll just trouble your lordship a bit more.
This is Delhi High Court.
My lord, yes. This is, my lord, again inordinate delay in trial.
Okay.
This is with respect to that ratio. My lord, the next one is, these are all NDPS Act, my lord. My lord, the next one is also on similar factors. That is of Supreme Court.
Yes. The third one?
Yes. The third one is
Jasaram.
18. That's of Jodhpur.
Now Jasaram is on what?
My lord, this is also, my lord, paying.
So your basic case is, yeah, your time you have spent there and without being tried.
So gives that stringent condition with respect to furnishing every bank details and everything because of the situation.
Okay,
We are
there,
ready to furnish whatever stringent condition your lordship shall impose. And the last is, my lord, the custody was for 4 years, 1 month and 28 days. That's paragraph 3. This is also relating to such point. And my friend has relied on an opposition, my lord, where, my lord, she has at length discussed certain facts, my lord, which are already contained in the judgment of Justice Khouds, my lord, from paragraph 23 to 35. So this is not something new. I am not delaying the court process, my lord. I just want to point out only the paragraphs. If your lordship kindly takes a note of.
Okay, that's all?
Yes.
May I please, your lordship?
You filed an objection to
Yes.
this?
Objection is
Yeah, what
there.
is the main ground there?
Main ground is that your lordship, he is absconding since 2001.
He's
He is absconder since 2001.
declared.
Yes. Yes, your lordship. To that effect, my lord, paragraph
Absconder since when?
2001. And the chassis is registered in his name. That has been located. That is given in my paragraph number 13. My crucial paragraphs are from lordship.
Now, what happened to the record?
To that effect, I have no knowledge, but
No
CBI
knowledge? You are the CBI counsel?
No, here, I am not in the trial court, Lord.
No, I understand that,
the-
but
but
you
the
are
trial is
representing,
going on.
CBI, madam.
Has reconstructed.
You are representing CBI, madam.
CBI
Now, if you say I don't have any knowledge, then whom do I go and ask?
The CBI has reconstructed. That
Should I go to the trial court and ask the CBI counsel there?
admittedly, trial is going on. Because the order sheet has been annexed by my learned sisters. And that shows that the trial is going on. All these proceeding start from 73. That means trial is going on, and she has admittedly said the witnesses are being examined.
My lord,
Okay.
51 witnesses.
Yes,
Is
so
what
it will
this
take time. It is delayed only because accused is absconder. That is one of the reason. That is one of the reason. And he is a habitual offender, your lordship. And he is carrying in his chassis, they are carrying a more than 2,600.
You show me the paragraph where you have stated that he is an absconder,
Yes, I am coming to.
and any details have been given there?
Yes. And paragraph number 4, lords, 105, that is with regard to the comment.
Paragraph number?
105, subpara 4, that is with respect to the parawise reply, A4.
No, I'm not getting it. Yeah, I'm asking for the.
105.
I'm
Page
asking.
number 105.
105, okay. 105, para
4.
4.
That is in regard to the para number 9 of the application filed by the accused. It is submitted that bail granting order dated 29/1/2001 passed by the Honorable High Court of Gauhati was set aside. Then the accused petitioner Dhan Singh had absconded intentionally, and he did not appear before the learned trial court at Tejpur for facing the trial of the case. He had absconded and avoided the process of law. After long time period gap, he was again arrested by CBI from his native place, that is village Balihar, PS Semari, district Buxar, Bihar on 26/9/22, and he was produced before the learned trial court on 28/8/22. And the trial is started. Case record has been reconstructed by the CBI. That is why the reason when the witnesses are being examined day to day. Now I am coming with the detail.
Yes.
104. Our crucial paragraph will start from, your lordship, from page number 100.
Page number?
99. Page number 99. That is para 10. The license number in the name of Mohan Singh, so and so, Charali Ganj, Cuttack has not been issued by the licensing authority. So even the license which was given to the driver, it was not issued by the licensing authority. Furthermore, the investigation has revealed that as per the record of RTO Vanarasi, the registration number UH so and so 1728 is allotted to moped registered in the name of Rajinder Prasad. August Kunda Vanarasi, which has engine number 11041285, and this was registered with the RTO Vanarasi in 1985 and is still in the name of Sri Radhesyam. Now I am coming to next paragraph. Disclose that the permit number so-and-so recovered from the truck number so-and-so on 10/4/94 was in fact issued by RTO Varanasi in the name of Punithara Mathayo Pal, which was registered with RTO Vijayawada, and the NOC was issued for the registration of this vehicle with DTO Mirzapur under the administrative control of RTO Vanarasi. This permit was valid for the period 25/3/92 to 24/3/94. Next paragraph, which is very important,
No,
investigation.
these are all, I mean, typically on the merits of the thing.
Merits of the
I mean,
case.
see, our contentions are very simple. That,
From
that,
here we are drawing your lordship that he is running his chassis is in his name. He is plying the truck in the name of different person, even the license, the driver who is holding the license, that is also fake, that is issued in the name of moped, and that has been confirmed from the RTO. Now, if Dhan Singh is at this stage, if he will be allowed on bail, then total this trial will be installed, because he is already a habitual offender and there is every likelihood that he will abscond. And earlier also, when the direction has been given to him to appear, he did not appear in the trial court to face the trial.
where is that? Is there any, I mean, have you pleaded that?
Yes, we have already pleaded, your lordship. I am coming to that. That both the oral and documentary investigation.
Page, para?
This is with regard to the fake number plate of document 104.
No, that he is he is a habitual offender and he has not appeared before the court in spite of directions. Is there any material he have brought on record?
No,
In your
earlier
objection?
the Honorable High Court has already dismissed his petition, your lordship.
Where is that?
Page 40.
Page 40.
Page 40, which my learned sister has already gone through.
No, madam, you are submitting that he is not abiding by the order of the court. That's why it was cancelled.
Once he was
So
at
is
that-
there, I mean, do you have that order? I mean, why it was cancelled? Where?
It was not cancelled, he is absconding after getting the bail.
No, you said bail was cancelled earlier.
No, there is a specific order on 16/10/23, which my learned friend has already gone through. And another order is here of, I'm coming to that, your lordship. In terms of the page 67, in terms of the above observation, the criminal revision petition is stand dismissed and the order dated 16/10/23 hereby impugned order dated 5 so-and-so passed by the learned judge Sonitpur so-and-so. Corresponding CBI case number so-and-so was suspended, is stand recalled. The criminal revision petition is stand disposed of. This was the big order of our Honorable High Court. And the reason is been given in the paragraph number 67. It is true that although this case was registered against Mohan Singh and Ramesh Chandra Jaiswal, they are not the owner of the vehicle bearing number so-and-so, so-and-so, and as such other registration number, the submission of the learned counsel of the petitioner cannot be ignored that the trial is dragging at a snail pace and only 12 out of 51 have been examined so far in the wake of foregoing discussion at this stage. I am reluctant to quash the proceeding. Page number 67. Thereby the petition is dismissed with direction to the learned trial court to expedite the trial. This was preferred by Mr. Dhan Singh.
After this order of 16/10/2023, there was another order probably.
This judgment was pronounced on.
No. You come to page 40.
40, your lordship.
the last paragraph, the prayer of the petitioner for bail as well as quashing shall be considered on the next date fixed. So this is on the revision petition itself.
No, this is different, Your Lordship.
Hmm?
Let me verify that.
No, this is,
IA 1011.
so this IO was filed in the criminal revision petition or
Yes,
something
yes,
else?
yes, my lord.
And
Yes.
Huh?
this is
In the same case?
206.
If I just take
No,
one
no,
minute
once,
of-
no, what,
This is
wait, wait.
206.
My lord, the thing is, my lord, criminal revision was filed.
Then IO was filed.
Justice Chaudhary was of the opinion that this person cannot suffer inordinate.
Correct. Now,
He actually suggested us to
Understood.
file this bail application.
understood.
In
Now,
the meantime, my lord, 174A was allowed.
then what happened is after this order,
My lord, we moved the criminal revision petition. Since the court directed that this should be done in an expedite manner, we did not press the bail application.
right, so the whole matter was heard.
Whole matter was heard.
Okay, anything else?
And
Page
I have
69 is that
adjustment.
order, my lord, where we did not press and this bail application was accordingly rejected.
I have
So your
adjustment, Your
bail
Lordship.
was never cancelled or something like that?
No, my
There's
lord.
nothing.
Before this court, this time after arrest, no.
I have
And
the-
my lord, the order which she is actually trying to project of the Supreme Court, my lord, that was there in a compilation which we had given to the.
No,
court.
let me
I have
let me
not
first
yet-
see, madam,
I have
what
not yet
she
filed,
say.
Your
Let
Lordship. Yes.
let me see what is there, then we'll know.
The first one is with regard to the MP, Your Lordship, at para number 12,
First one is regarding
absconder,
absconder.
para number 12, Your Lordship. From this material and information, it is clear that the present appellant.
Wait, which one? There, I mean,
MP. State of MP
Srikant
and Pradeep
Upadhyay.
Sharma.
Srikant Upadhyay case.
Yes, Your Lord.
Para,
Srikant Upadhyay.
you have written para 24-25. And you are reading something else, it seems.
24-25, Srikant Upadhyay, yes, Your Lord.
Para 24-25.
24-25.
Yes.
Probably I have given that one. No, it is here. 24, we have already held that the power to grant a anticipatory bail is an extraordinary power. This is with regard to the anticipatory bail, but wherein it has said with regard to the withdrawn on fear of the so and so rule, and the question of his grant should be left to the caution and judicious
Yes,
discretion by the
definitely.
court, depending on the fact and circumstances of each case. While called upon to the exercise the said power, the court concerned has a very cautious
Transmit
the
to
grant
this
of
fellow, no?
interim protection or protection to the accused in serious cases may lead to miscarriage of justice and may hamper the investigation to a great extent, as it may sometime had to temper or distraction of the evidence. We shall not understood as to why it is a long and thereafter the conclusion, Your Lordship, and then I am coming to Your Lordship, this MP one. MP versus Pradeep Sharma. Para 12. It is clear that the present appellant was not available for interrogation and investigation and was declared as absconded.
MP versus Pradeep Sharma, which one is this?
I have given, Your Lordship.
You have given three cases.
This one.
One is Bablu versus Madhya Pradesh.
One is Madhya Pradesh and this one is again on the absconder only.
This is para 12.
Para 12. Appellant is not available for interrogation and investigation and was declared as absconder. Normally, when the accused is absconding and declared as a proclaimed offender, there is no question of granting anticipatory bail. We reiterate that when a person against whom warrant has been issued and is absconding or concealing himself in order to avoid the execution of warrant and declared as a proclaimed offender in terms of section 82.
He was declared absconder where do I find it?
He is
From the
declared-
records?
He is declared absconder because from last 10 years he was.
No,
not
where
available.
do I find it?
I have to get the lower court's record, Your Lordship.
No, there should be somewhere, no? I mean, it has to be from the, I mean, from the court only.
From the order sheet, it is revealing.
Which order set?
No, it is not with me, lower court
You
record.
can go through this. It is there. You just flag mark it and give it to me.
And another one is I am coming to the state by the Inspector of Police. This is of the Supreme Court, Your Lordship.
Hmm?
एक बार रखो सी। Section 37 of the NDPS Act deals with the bail to the accused charged in connection with the offense involving a commercial quantity of a narcotic drug or psychotropic substance.
No, that's fine. That's fine. I mean, that's fine. I mean,
That is
Miss-
clear.
Madam,
And another one is of the High Court of the Madhya Pradesh, Jabalpur. Your
that you have given the paragraph. I'll go through it.
Yes.
You just give me that.
My lord, while my learned friend is looking at, my lord, I just want to point out only one paragraph from the judgment of the, which was delivered by this honorable court in the revisional application.
Yes.
Page
which-
67, my lord, kindly
Page?
chance. Yeah, 57.
57.
Paragraph 39, it starts from 56, the last but two line, my lord.
Hmm.
My lord, where it speaks of learned counsel for the petitioner has reiterated that there is no scintilla of evidence that the petitioner was aware that the drug number such
Page,
was carried.
para.
Para 39.
39. Okay, page 57, right?
56, 39 is the starting paragraph.
Hmm.
The lordship has got it. Learned counsel for the petitioner has reiterated.
Correct. So the next,
Yes.
the page 57.
This is, the court has noted the fact that the vehicle was searched on the following day after interception of the truck on 9/4/1994.
Hmm.
The truck, the court has also noted that the fact that only 12 out of 51 witness has been examined so far and 2 witnesses were examined in presence of the petitioner, whereas other witnesses, that is 10, were examined in absence as per the procedure of 299. My lord, when they have already invoked 299, my lord, out of 2, instead of 12,
Hmm.
the entire witnesses could have been examined. And I could have been declared absconder, but that was not done. And instead, my lord, the entire court record was lost. My lord, the entirety of this judgment actually elucidates the entire backdrop. So I would just beseech your lordship kindly take a note of this judgment and the judgment of Justice Arundev Chaudhary, because every minute details has been considered, considering the LCR.
Sure.
And my lord, the next page I would just trouble a bit because my friend is looking for the document which your lordship has wanted her to. My lord, page 58, the very next page, paragraph 45. My lord, this is the order which was passed by the court below, the trial court. It is further contended that the order dated 3/5/2023 passed in CR case number 6 of 1996 reflects that the supplementary case record produced before this court also shows an original letter such and such submitted by H.S. Chopra, Deputy Superintendent of Police CBI, wherein he submitted before the court that the briefcase containing the original documents and the statement of the witnesses was stolen in the train while traveling from Guwahati to New Delhi. But he has submitted the photocopies of the document and the examination of witnesses to the court for record purpose.
Now the case record has been reconstructed, madam.
Photocopies, my lord.
Already reconstructed. So trial is going on.
Well, the trial means today now, as on date, my
No,
lord,
madam,
there has
already,
been-
see now the records are whatever, records are there, trial is going on.
My lord, we
So,
are
so,
taking from the
no,
trial.
see, madam, now thing is that the lost of the records, don't you think that has become a history now?
My lord, because the thing is that today, even today, if your lordship really, we have brought the supplementary case record. My lord, this is what was furnished by
No,
the
that,
CBI.
I mean, that,
The court only, my lord, we was also provided a copy by the CBI. And my lord, from there, your lordship will see
then you'll have to come for a revision again with different grounds.
that. My lord,
And then you'll have to come for a revision for a different ground, with different grounds.
my lord, that is
Not on the bail, right now.
thing which I'm really not getting into. That is why I did not get into the merit. My lord, the scenario is today that today, even after a year from the date when this order was passed,
This
but
is,
rejecting
this was not
application.
expected from CBI, but now thing is that since it has gone, it is going on now your ground is different altogether. For bail is,
The only-
for the ground of bail is different, so we'll consider that. obviously.
Because my
Madam, I
1
mean,
year,
you can give it to me later on, so we'll conclude this.
I will have to
Uh,
search thoroughly.
Uh,
Orders are not available, appears to me.
It was not there, my lord.
Order is
For
not
us also.
available.
Then how you are, I mean, how you are saying it's absconder?
Because as
He's
per
declared
instruction
absconder.
of the CBI
As per
committee.
instruction and my lord, 174A since was added. That is the reason.
You please find out and like, try to give it to me in the, during the course of the day.
We have to get instruction if they had some paper with them.
And
From the
if, see,
proceeding.
if they have some papers
Then I will-
declaring him as an absconder, please give a copy to me and serve a copy to her also. Over the mobile phone or whatever, she will give you a copy also.
Yeah.
But there is one local advocate, my lord. so-
So that can be given to him. So we conclude and we'll pass the order.
Orders are not here.
We'll pass the order. It may take a couple of days.
My lord is not an issue.
Heard you, Madam Sanyal, right?
Yes.
Your name, your full name?
Tutopa Sharnal.
Yeah, heard, MS Sutapa Sanyal, the learned counsel appearing for the accused applicant. Also heard MS M Kumari, the learned special counsel CBI. Hearing concluded. We'll keep it reserved or we'll pass it. We'll keep it reserved, but like we'll give it, I mean, at the fastest possible time.
The order is not here. I have to.
So you find it out, and if you find it, if you can locate it, then please give a copy to the court master and serve a copy to them also. Because that will be, Madam Komari, that will be a relevant factor in deciding this bail.
Definitely you're not.
So that's what I mean, since you are submitting, I mean, if you can produce some material substantiating that, that will be good.
I will take one day time to contact the CBI people and I will get the paper with regard to this issuance of
Well,
warrant and
Mm.
82,
Can I
83.
just show your lordship one page? This is the supplementary case record based on which the trial is on.
Mm.
My lord, may I just hand over this? Whatever madam is going to give, that is there. My lord, this is what was there with us when we argued. the
Okay,
case.
let me see what is that.
And nothing is signed, my lord. Not a single order is signed. This is what is there. My lord, kindly see.
I think that is, I mean, that record is already lost, isn't it?
Well, this is what is there. This is the case record as it exists today. My lord, 68, this side of the page, my lord, lordship sees.
Mm.
This is what was all recorded. Because I do not want to run away because I know that I have not committed anything. However, my lord, all I was seeking is a bail. But with an undertaking, whatever strict condition your lordship shall impose.
Okay, that's fine.
I'll get the
Mm.
paper and then I'll furnish you. Much obliged.
Much obliged.
Itu tatul. Yes.
14 ballot case that is not received to them.
A respondent number 2 service is a POXO matter.
Yes,
Hmm? Notice is yet to be served, no? Respondent number 2.
It is served, my lord, then amicus may be appointed, my lord.
Served, but like office record says it doesn't.
On 7/11.
Hmm?
On 7/11,
7/11,
2025.
what? Service report of respondent number 2 has not been received on 3/12/2025, 8/1/2026. And you are saying 7, what?
11.
7/11, there is no noting. How do you know, how did you get to know about this?
This is a, my lord, to report, my lord, wherein, my lord,
What report?
you have taken a step in register post. How did you take steps? He has taken steps by registered post.
No, that has to go through your office, no, PP's office. You have not taken steps. You have taken steps. No, this will not do. This will not do. There is a, I mean, there is a rule, I mean, there is a notification. Heard Mr.
P. Saraugi.
P.
P. Saraugi.
P. Saraugi, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwa, the learned APP for the state. Office note dated 8/1/2026 reveals that service upon respondent number 2 is yet to be completed. However, from the office note dated 10/11/2025, reveals that notice was issued to the respondent number 2 on the very same date, that is 10/11/2025. Taking into account the aforesaid fact that that service, the report on service of notice is yet to be received, in spite of sufficient time has elapsed, this court is of the opinion that an amicus, a learned counsel should be appointed as amicus curiae to represent the respondent number 2 in the instant case. Accordingly, Srimati Manisha Karen Brown, the learned counsel, is appointed as amicus curiae to assist this court on behalf of respondent number 2. Let the matter be listed after a week.
Interim may be continued. Interim may be continued.
Interim was also passed earlier, shall continue to the next date of listing.
I would have. The request to call for your option.
Hmm?
Oxco 6 is there and also 351 subsection 3.
The record was called for,
Record
record is
called.
received. You are appearing.
My senior is on leg for amicus.
Amicus curiae was appointed.
R. Chaudhary, my senior, is for amicus curiae. She is on leg. So kindly take up the matter after some time.
And also I'm behind the bar for 222 days here. And also victim was examined.
Okay, later come.
Ma'am, in this case, your lordship record has been called for.
Mhm.
But two documents I didn't found there.
So, yeah, NDPS commercial quantity,
Yes,
when was, I mean,
first of August, they were arrested,
1st of August.
2025, 194 days.
Yes.
In this case, two witnesses already been examined, Your Lordship.
Hmm.
And that record is not there, but the certified copy is with me. Now, in this case, Your Lordship. if you-
Yes.
If Your Lordship go through this,
So, yeah, I mean, we have only one petitioner.
only one petition.
Hmm.
But the FIR is page 15, Your Lordship.
You moved a bail there, lower court.
Yes, that has been released.
That was rejected when?
It is on 1410.
1410. How much was the quantity recovered?
Here the actual requirement, there is a different figure in different documents, Your Lordship. Actual figure, it is 284.55, somewhere it is written, somewhere it is written 64.
But that will not make any difference because it's already a commercial quantity, isn't it?
But here,
Yeah.
Your Lordship, if
Yes.
Your Lordship go through the order of the trial court, Your Lordship, judicial magistrate, then something different figure come out.
Where page?
Yes, Your Lordship.
Page
Page 33, Your Lordship.
33.
33. First, I want to show Your Lordship. Similarly, 34, Your Lordship. I also allow the drawing of the entire sample 284.
So I mean, different quantities were there, right?
In this case, it is.
And the
written
empty polythene
284.
contains so and so.
And
How many these things were there? I mean, it's pouches, I think.
packet.
Yeah, packet pouches.
24 packet.
24 packets
Yes. 24 packet, you know,
of different quantities.
of different quantity.
So it came down to how much?
284.64, somewhere it is written, somewhere it is written 4.55.
280,
4.55.
4.55.
Yes. Now,
Now, two persons have been examined.
two witnesses has been examined.
Two witnesses have been
Yes,
examined.
these are
How many witnesses were there?
total 8.
8.
Yes. One independent is remaining, other
Eight.
all police personnel.
2 out of 8. So one yet to be examined, yes. Sorry, one independent witness is yet to be examined. And two seizure witnesses have been already examined.
Now, in this case, what happened, Your Lordship? The heroine was within the transparent polythene pouch,
Hmm.
polythene paper. And along the total quantity comes along with that polythene paper.
The polythene has been, they have minus it.
No, they didn't minus. Inclusive.
Yeah, when inclusive these pouches. So one pouch is weighted 1 point some gram, they have stated,
1.23 grams.
1.26 gram. So 1.26 gram into 24, it will be 24 grams maximum.
Yes.
So if you minus 24 grams, how much it will remain?
24, some 29 something it will come.
Hmm?
29 something it will come. Because 1.23.
Then it will come to intermediate quantity. No,
Slightly more.
not slightly more. I mean, it will be more.
2.50 is
250 is this thing, no?
Yes.
Commercial.
Something more than 250.
So ultimately commercial quantity.
But if your lordship come to the page 38,
Hmm.
what happened? This sample has been sent to the FSL.
Hmm.
One packet is divided into two.
Where do you get it?
Yes, page 38.
Hmm. From each packet, two separate samples are drawn. Two
Yes.
separate samples are drawn.
Yes.
So?
Separate each packet, then
Each packet, two samples have been drawn.
yes.
So
Now P12, the total is P11 and P12. The
Hmm.
packeting has been drawn. Each packeting divided in two packets.
okay, then
Then if your lordship come to this quantity, the quantity is how much quantity? P11 and P12
hmm.
or P12 to P121, that has been detailsly given here. But in this case, what happened? Though what is the total of the 48 papers? That has not been mentioned here.
That is not required. Now see, I mean, your weight has been done before separating these packets to two packets.
Yes.
Correct. Weight has been done prior to that. So they have already measured it. After measuring it, only because to send it to the FSL, they made it to two packets. After that, they send it. So that will not make any difference about the weight. But if you have some technical other grounds that like those have been separated because of this, you have I mean, that is not the procedure. Something like that, some ground is there, that's a different thing.
No. Only in this case, in case of quantity.
No,
there are other-
whether by separating these to two packets,
Yes.
whether any statutory provision has been violated. Is it your ground that some statutory provision or rules, how it to be separated, how it has to be sent to the
Yes.
FSL, Is there any ground that has been taken by you? No. You are only saying that like that has been separated and that was not weighted. I mean, that is not required to be weighted. Why? It was already weighted. After weighting it, they found it to be 284 grams with the
Earlier it is
with the
280.
packets, with the packets.
The
The minus packets, it will be something more than 250 packets, 250 grams,
253 something.
253.
Yes.
So it's a commercial quantity. So regards of 37 will be applicable. So you'll have to satisfy that, I mean, court has to be convinced that 37 is complied with. Then only you will get
Then your lordship go through the witness.
then only you will get,
Statement of witness, your lordship.
then will, no, statement of witnesses is fine. Statement of witnesses will be, I mean, that will be looked into during the trial.
Oh,
You give me the copies, statement of witnesses. You
Yeah.
have copies?
Yeah.
Give me. Borua, two witnesses have been examined, he is saying.
Well, only my lord difficulty is that when after status report not received.
Not there, yeah.
Yes, can be, but nothing is, even my lord, order framing charge is also not available.
Yes.
my lord. So may I pray, my lord, that has to be calm, my lord, because we have to peruse, my lord. Because there is just, it is a searched case, my lord, charges have been framed. Now, as per my learned friend statement, my lord, two witnesses have been examined, my lord.
No, to examine that, the court will consider that. I mean, why should we keep this pending, Borua? Is it required now?
That
It is required, your
it
lordship.
is up to your lordship, my lord.
Up to the record, come let's.
You have been arguing for so much of time. You have not stated then that up to the record is required. You have wasted my time then.
I have said some documents has not been in there.
No, you stated that like you have got the certified copies of two statements. If we produce before the court, I don't think like we need to go through all the trial court records. This is there already. Only thing is that like the two witnesses
Your
have been
lordship will
examined.
get some
No,
time.
we'll conclude it and we'll decide it. You give me
Then-
that
then-
copies.
Then your lordship, you have to hard in this case,
What heard?
evidence with regards.
why-
That's what I'm saying. You give it to me, the copies. You give me the copies. I'll consider those.
Would,
In this case, both the witnesses are declared hostile, your lordship. Nothing has been found from the accused persons at the time of search.
No, one has been declared hostile. Other one also, where?
Second one.
No, only second one.
Second one
PW2.
is declared, but the second one is also same statement. First one is also same statement, though it is not declared,
No, not declared.
but he is not supporting the prosecution.
You have the certified copies.
Yes.
With you, no?
Yes.
This can be considered, no?
yes, yes, my
Hmm?
lord. This can be considered, my lord. Only, my lord.
You have seen this, no?
Yes, my lord.
I
My lord,
mean,
whatever, my lord, the PW1 is stated, my lord. My lord, what happened, my lord, they are carrying the contraband, my lord. Their vehicle, my lord, collided with something called, I mean to say,
Yes,
my lord,
and there is
got
an
accident,
accident.
my lord.
then
My
it
lord,
was,
The injured person, my lord, these are the accused person, my lord. They were sitting in the roadside, my lord. Then police searched them, nothing was recovered, my lord. Then police searched the vehicle, my lord. Then from the vehicle, my lord, this contraband was recovered, my lord.
Not
but
from the
they were
vehicle.
traveling in the,
Yes, my
they're
lord,
traveling in, they're traveling in the,
That is
that,
why.
and
That is why,
they
my
were unlucky that they met with an accident.
lord.
the-
That is why, my lord.
So,
No, within it, that is not there.
Huh?
Only the bag is found in the national highway, not from the
How
car,
can it be, my lord?
not from the car.
Let them prove it before the trial court, my lord.
No.
That bag is not belongs to them, my lord.
so I mean, Mr. Upadhyay, nothing else is there. No? I mean, you have argued the case. I mean, we have heard it. Then we'll pass an order. What's the point of waiting for this? Only for this?
Because today I received it, so I.
No,
maybe
correct.
have
I
to go
mean,
through the
this you have gone through. No? I mean, what else you want to
I have
argue?
gone through, but there are some similar judgment is there, so I cannot obtain it.
That then you give the judgments to the court master today.
Today I cannot,
When you can give it? I mean,
tomorrow.
Okay, you can give it tomorrow, then I will pass the order tomorrow. But this thing is concluded,
My
hearing concluded. Heard Mr. N. Upadhyay, the learned counsel appearing for the accused applicant. Also heard Mr. R.J. Boro, learned APP for the state. Uh, Mr. Upadhyay during the process of hearing has submitted a copy of the recording of deposition of PW 1 and 2 for this court, which has been verified with the certified copy by the learned APP, full stop, that the copy so received is marked as X and kept on record. A hearing on the matter is concluded. Judgment order is reserved. In the meantime, the learned counsel, Mr. Upadhyay, will submit before the court, will submit, some judicial pronouncements in support of his case. You give it tomorrow? By tomorrow you give it to me, then tomorrow we'll see when it can be passed. Because I don't think anything else, is there, right, Mr. Upadhyay? If you wait for the records, then your matter will be delayed. You have already given the certified copies, copies of the certified copy. Only these two are ready, otherwise, so this record is there. Case there is, TCR is, you can write it, TCR is received. A scan copy of the TCR is already produced before the court. So we'll pass the order. You give it to me if possible today, otherwise by tomorrow, you give it to me. So then we can pass an order. Put the judgment reserved, yeah. I'll just rise for 5 minutes. ये तो आगे में
This is a solicited case, Lordship, also. This time, Lordship. This year,
Heard Mr. So-and-so, learned counsel appearing for the accused applicant. Also heard Mr. R.J. Burwal on it. APP for the state. This is an application you write. That then you write, date notice be issued on respondent number 2 through to the registry in terms of the data, in terms of the prevailing notification issued by the Gauhati High Court. Notice to respond number 1 is dispensed with. Call for the TCR in connection with special FOXO case number 118 of 2025 from the court of the special judge FOXO, Lakhimpur. Let the case be fixed on.
Any member of the
Hmm?
scan copy will be called for, my lord. So after receiving the scan copy, my lord. On 23, my lord.
23. Scan copy of the TCR, no? Registered.
Because to call for your, when the petitioner is a student, he's of 20
Hmm,
years
hmm.
old. Petitioner is a student, your lordship, is pursuing his ACES, high secondary student, your lordship, Disney College, your lordship, 20 years old, and also he's behind the bar. He was arrested on 3rd of January, 3rd of July, 2025, your lordship. 222 days behind the bar, your lordship.
222
days, your lordship. The incident was took place, and whatever may be, he have to face the music before the trial court, because trial court already examined the victim, your lordship.
Trial court examined victim.
Victim.
How many witnesses are there?
I said, almost 15 witnesses.
15 witnesses are there. So only victim has been examined.
Yes, victim has been examined.
Total 4 witnesses examined, my lord.
Hmm?
Total 4, including victim.
4.
And there are 12 witnesses, my lord.
12 or 15?
On the page number 22 is a search sheet, my lord.
12 witnesses.
There are 1, 2, 3, 4, 6, 7, 8, 9, 10, 11, 12. It is husband or name is a father.
In fact, there are 10 witnesses, Lordship. After 8, your Lordship will find 9 and then again 12. So only 10 witnesses.
10 witnesses, 4 already examined.
Victim statement is, victim evidence is, my lord, in the scan copy of the record, my lord.
Hmm?
Victim statement, evidence is in the scan
Yes.
copy of the record.
Yes.
Your Lordship, because the tribal court will take the other reports as your Lordship. If the evidence is recorded that there is a question of absconding and also they will not going to influence the witnesses, your Lordship. Because it's 20 years old, your also, and also higher secondary student, your Lordship. 20 years of age, your Lordship. 222 days behind the bar, your Lordship.
Lordship may peruse the victim's evidence, my lord, because he has deposed, my lord. The factor is her age, my lord. She has stated that they had a love affairs between, my lord, both of them, my lord. But regarding the consent of physical relationship, my lord, considering her age, my lord, that will not be applicable.
Yes, madam.
The offense is very serious, Lordship. She became pregnant, Lordship. And Lordship,
Given birth
the
already.
time of FIR, 5 months pregnant, Lordship. It's 1/7/2025. And trial proceeded, Lordship, within a very short span of time. 4 witnesses were examined, Lordship, within 5 months. It started from 9/9/2025, and today is the today is the date fixed before the learned trial court, and PW4 was examined on 16/1/26.
And also delay of lodging FIR, it's a clause 8 of the format of the FIR, Your Lordship. The delay has to be explained, Your Lordship, in the body of the FIR, Your Lordship.
Delay of lodging the FIR, Lordship, they were not aware about all the facts, and when she became pregnant, and after 5 months only they came.
Art Mr. T. Rasko, the learned counsel appearing for the accused.
Arti Hazarika,
Sorry. RP Hazarika, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borwa, the learned APP for the state, as well as Ms. R. Chaudhary, the learned amicus curiae appointed by this court for appearing on behalf of respondent number 2. This is an application, you write, huh? Application, very short. On 172025, 25, the informant, that is namely an informant, namely Sajeda Khatun, lodged an FIR before the officer in charge Bizni police station, alleging that about 4 months back, the accused person committed sexual intercourse with the informant's 14 years minor daughter by forcibly taking her and against her will. It was also alleged that earlier also on several occasions, the accused has committed accused had sexual intercourse with the informant's minor daughter with, against her will. Lastly, it was alleged that 5 months back, at about 12 a.m. night, the accused committed sexual intercourse with her daughter by forcibly threatening her life, threatening dire consequences of life in an abandoned house situated in the land of one Nayab Ali, near the house of the informant. It was alleged that the informant's minor daughter got 5 months pregnant. How 5 months pregnant, full stop. How she did not disclose anything to anyone till that date, out of fear, full stop. After seeing the deteriorating health condition of the minor, when she asked her daughter, she has disclosed the incident, disclosed about the aforesaid incidents to her. Full stop. On receipt of the FIR, Bizni PS case number 87/2025 under sections 351 in bracket 3/65 in bracket 1 BNS 2023 read with section 6 of POCSO case was registered. Petitioner was arrested. Next paragraph, the accused applicant was arrested on 3/7/2025 and for last 222 days is behind the bars. after investigation, the investigating authorities has filed the charge sheet by by charge sheet number 81/25 dated 26/7/2025. And since then, and after framing of the charge, the trial has started. First, the TCR in the instant case has already has been produced before this court, which has been perused by this court. It is seen that it is seen that 10 witnesses has been named by named in the charge sheet by the investigating authority, and out of the same, 4 have already been examined, including the informant and the victim girl. Stop. The learned counsel, next by the learned counsel, waiting for the accused applicant, submits that the accused applicant is a 20 years old boy studying at high secondary and and he has already spent sufficient time, that is 222 days behind the bars. Therefore, considering his age and his status of a student, he should be allowed to go on bail at this stage, full stop. Par contra, the learned counsel, learned APP, appearing for the state, submits that from the depositions made before the trial court by the victim, as well as other by the victim, informant and other witnesses, a prima facie case has been made out implicating the involvement of the accused applicant in the instant case, full stop. Therefore, at this stage, we oppose the prayer of bail by the accused applicant, full stop. And MS R. Chaudhary, the learned amicus curiae, has submitted that since the case is of a rape on minor as well, minor, and after the rape, the minor girl got pregnant and thereafter delivered a child. This is not they are delivered a child, this is not a fit case wherein the accused applicant should be granted bail at this stage, full stop. This court has heard the submissions made by the respective counsel appearing for the respective parties, as well as gone through the TCR that has been produced before this court. After finding sufficient material against the accused applicant, as well as considering the fact that the minor girl got pregnant and delivered a child, and taking into account the stage of the trial, this court is not inclined at this stage to allow the accused applicant to go on bail. In view of the aforesaid finding, the instant bail application is rejected.
Please, Lordship. Office, on the respond number 2 is not yet as part of the office note. My learned friend can obtain instruction with that.
Sorry?
My learned friend can also obtain instruction with that. This was issued through the OC concern.
Heard Mr.
B. Bora.
Huh?
B. Bora.
B. Bora, the learned counsel appearing for the accused applicant, also heard Mr. R.J. Borua, the learned APP for the state, seen the office note dated 6/1/2026, which reveals the service, the report of service on respondent number, of service of notice on respondent number 2 is still awaited. Full stop. However, it is seen that that notice to respondent number 2 was issued on 18/12/2025 and 25. Therefore, having found that sufficient time has elapsed after issuance of the notice to respondent number 2, this court is of the opinion that an amicus curiae should be appointed to represent respondent number 2 to assist this court. Full stop. Accordingly, accordingly, Srimati Sneha Kolita, the learned counsel, is appointed as amicus curiae to appear on behalf of respondent number 2. The learned counsel appearing for the petitioner, appearing for the accused applicant, shall serve a copy of the application, copy of the bail application to the learned amicus curiae within 2 days. Let the matter be fixed after 2 weeks. 2 weeks?
LCR also
No,
not
after,
come. LCR has also not come, my lord.
It was called for.
That's the method.
Yes, if required, LCR may be called for.
LCR will be required, my lord.
Okay, since charge sheet in the instant case has already been filed, the registry to call for the TCR in connection with special P case number 87/2025 from the Court of Special Judge Pox Gulaghat. Full stop. Let the matter be fixed
After
on
2 weeks, my lord.
May,
after 2 weeks.
a date may be fixed if.
After 2 weeks, let it come.
Maybe.
On the last occasion, this honorable court was pleased to call for the 47 and 48 notice, madam, to ascertain whether the grounds of arrest were actually served or on the accused petition.
Those are there.
lord, my instruction was that no notice was served, that's why, my lord, I have taken.
No, it was there.
That's why this four directed to. If that is there, my lord, then definitely, my lord, section 34.
That is there.
But my lord, may consider also detention for 212 days, my lord, they are behind the bar.
212 days, quantity recovered.
Quantity, my lord, from two persons, from the petitioner number one, my lord.
Hmm.
75 strips of tramadol capsule, my lord, having.
So there is no question of, intermediate quantity or something like, it's a commercial quantity. There is no nothing like that. So section 37 will be applicable. At this stage, it will be difficult. Heard Mr.
M. Ali.
M. Ali, the learned counsel appearing for the accused applicant. Also heard Mr. Arjay Boro, the learned APP for the state. This is an application under so and so. The case, next paragraph, you read, an FIR was lost on 13/6/2025. To 5. One second. No? 13/6/2025. By one SI in bracket P of Lakhipur PS before the officer in charge, Lakhipur PS, alleging inter alia that on 11/6/2025 at about 10:18 p.m. on the basis of a secret information the police staff proceeded to the place of occurrence and searched the houses of you are Azizul Haq or Azizul Rahman?
Azizul Rahman.
My lord,
My lord, may I just.
Azizul Rahman alias Azizul Haq, my lord. the
Okay,
same person.
and Rumisa Khatun,
Mr. Khatun is the wife of.
wife,
Azizul
and Basit Sikdar is a brother.
Lordship. But relative, my lord, not brother. Relative, but nothing was recovered from Abu Basit Sikdar, petition number 3. And
The
petition
spot,
number-
क्या लिखा last में? House of the accused applicant Azizul Rahman alias Azizul Haq and one Rumisa Khatun, the wife of the aforesaid Azizul Rahman. Who is Jahangir Alam?
Another person. Another.
The strips were received from seized from where?
From two
House of
persons.
Jahangir
One is
Alam and
Jahangir and another is Azizul.
Okay.
From Azizul also.
And how this person got implicated? This Abu Basit.
As per my lord forwarding report, my lord, the Azizul implicated him.
Okay, and something received recovered from his? Huh?
Nothing was recovered.
Okay.
And that may be kindly considered.
Went to the house of as well as one Jahangir Alam from the houses of the aforesaid persons. The police recovered and seized 420 numbers of Simplex capsules from the house of Jahangir Alam and 10,800 numbers of Simplex plus capsules, 21 vials of suspected heroin in bracket net 1.84 gram and 2.039 kg of ganja were seized. Full stop. On receipt of the FIR, the police registered Lakipur PS case number, police station case number 80/2025 under section 21 in bracket capital A stroke 20 in bracket small b stroke 22 in bracket C small c stroke 25 stroke 29 of NDPS Act. During investigation, during investigation, the accused applicant number 1 implicated the involvement of accused applicant number 3 also, and thereafter, the accused applicant number 1 and 2 were arrested on 13/7/2025, whereas accused applicant number 3 was arrested on 24/7/2025. Full stop. Next para. The learned counsel appearing for the accused applicant submits that notice under section 47 and 48 of BNSS were not served on the petition on the accused applicants during their arrest. Therefore, the arrest is in violation of the mandates of Article 22(1) of the Constitution of India. Full stop. However, he further submits that the TCR in the instant case was called for. Call for to find out whether the aforesaid notices were served on the accused applicant or not. Full stop. The next para, the TCR, the aforesaid TCR in connection with the instant case has already been produced before the court. This court has perused the TCR and has found that section 47 and notices under section 47 and 48 are duly served on the on the applicants, on the accused applicants while arresting them. Full stop. Next para, the learned APP appearing for the state opposes the bill. Full stop. This court, after consideration of the materials available before this court, is of the considered opinion that the rigors of section 37 of NDPS Act shall be applicable in the instant case, and there is no material available before this court to dispense with the provisions of section 37 of the NDPS Act. Therefore, the instant bail application is rejected at this stage.
Yeah, please, madam.
Notice is not served, it seems.
Now she has appeared, my lord.
Oh, she's appearing.
My lord, TCR is already received, madam. My lord, this petitioner was arrested on 12/8/2025.
12?
8,
8?
2025.
2025. How many days total?
My lord, it is about
should always count these days.
My lord, about 6 months more. This is already charge sheeted, my lord.
Charge that how many, I mean,
My lord, charge sheet submitted on 22/9/2025.
and how, I mean, trial started, charges framed.
Oh, my lord, what happened in this case, my lord? The court is lying vacant since September, my lord.
Since September,
2025. The POCSO court at Tinsukia is lying vacant, my lord. So nothing has happened
since
September 2025. POCSO, Special Judge POCSO court at Tinsukia is lying vacant, sir. That the lordship will find.
what,
Total 9 witness in the,
no, the court
Charge
is lying vacant. I mean,
Court is
how,
lying
what is to be done?
but regarding the one girl is 14 years old, kindly peruse the 183 statement, I have flag mark,
No, that I will do, but like the problem is that,
Yes, that is.
what is to be done on that?
Technical,
My lord, may kindly peruse the, my lord, victim's statement. I have annexed, my lord, page 18, which is supplied along with the, my lord, charge sheet, my lord. My lord, may kindly see, my lord, page 18 and the, my lord, medical report is stated in the charge sheet.
Page?
Page 18, my lord, victim statement, 18, my lord.
Class 9 girl.
My lord, she stated to be 16 years. May I read, my lord, or not?
Yes.
My name is so-and-so. I used to study in 9th class at.
No, why are you disputing this? I mean, that he is not 16 years, is there any material?
No, I'm not on the age, my lord.
Then?
My lord, the incident, what has happened, my lord, actually. My lord, she voluntarily went this boy, my lord. She stayed in the hotel,
She's 16 years old.
16 years, but my lord, the conduct and my lord, what happened actually.
But you know about POCSO Act.
The POCSO it is there, but the entire, my lord, I'm for the bail, my lord.
If you go in voluntarily also, no, but you are on bail, that's correct. I mean, but thing is that, I mean, whether you go voluntarily or forcefully, that doesn't matter. It becomes irrelevant.
And my lord, may kindly see the, my lord, medical report at page 26, which is stated in the, my lord, the chart sheet. That is totally opposite, my lord.
Where?
Page 26, my lord. My lord,
Laboratory analysis, yes.
medical report, opinion. May I read, my lord? X-ray, shoulder joint emphasis.
You read this thing.
My lord, opinion of doctor. My lord, in the, my lord, may I read, my lord?
Okay, you read.
Opinion of doctor. There is no evidence for any signs for sexual intercourse or signs of penetration of penis into vagina, mouth, so-and-so, of insertion of any object or any part of body into vagina, mouth, so-and-so. There is no sign of manipulation of body of the victim so as to cause penetration.
How old is this guy? This person, accused person?
Accused is, my lord, 24.
24. Where is he studying?
Hello?
He is studying.
No, ma'am.
What is he doing?
He is a petty businessman, my lord. He is having a small, my lord, tea garden. I have stated in paragraph 1, my lord.
Mr. Parasar, medical is totally against you.
Yes, but thing is that subsequently medical was done, but not immediately. She was taken to Arunachal Pradesh, stayed here, subsequently taken back. And
it seems he's a relative.
Brother means neighbor, from the same village.
No, more সম্পর্কীয় দ্বারা, please.
Okay, dada.
That statement and 183, I have flag mark. This is the victim 180 statement,
183 yet flag mark.
183 also there.
In the order sheet, my lord, if lordship may sees the orders, my lord, from 10/9/2025, it says, my lord, PO transferred. In the order sheet, my lord, from that order dated 10/9/2025, in all the orders, PO is transferred, my lord.
So from which date you said?
On the order sheet.
Which date?
From 10/9/2025.
10/9/2025.
PO transferred, it is reflected in all the orders, my lord.
That's why, my lord, all the charge sheets is submitted, but there is no progress.
Instruction from the respondent number. And he has shown an affidavit where he stated that under misunderstanding and emotional distress, he lodged the FIR. But otherwise, he does not have any objection if bail is granted.
We see mother.
Mother.
Mother, malat, in POCSO case, malat, mother, father will not do, malat, the statement of the girl is malat vital. And in a statement before the magistrate, she clearly stated implicating the boy, malat. Someone compromising it, POCSO case, someone will come, malat, even then father or mother, malat. What happened to the girl, she knows, malat. And she, in her statement, both 180, 183 clearly.
She is a minor, guardian is saying.
Guardian is saying, Malat, but Malat, what is happening with the girl? She in before the magistrate, she has clearly stated. How the mother can nullify?
See, her statements are, Mr. Parasar,
Yes,
the
Malat.
183 statement.
Physical regarding
No,
physical.
only that.
Yes.
Not, no other, I mean.
Yes, but
Not,
maybe
see,
concern at this stage, but
nothing forceful, nothing. She voluntarily went.
forceful
So you need to
makes-
see all these things. She's more than 16 years of age. And that judge is not there. Trial is delaying,
Well,
getting delayed. Then this person doesn't have any problem. In addition to that, medical report is totally against the
Medical.
prosecution
Malat,
story.
regarding Malat.
No,
16 years-
I'll allow
yeah,
this person to.
Malat,
I will allow this person to go on bail.
My prayer is that Malat, regarding 16 years old, he will not get any benefit. Only Malat, regarding court is not sitting, but there is technical.
The medical?
Medical,
You go through the medical?
yes, Malat. Medical was done subsequently, Malat, 2, 3, 4 days after 3,
No,
4
whatever.
days.
If you are disputing the medical opinion, then I do not know. You go through it.
After 3, 4 days, because of that, maybe in case of consent, Malat, if there is no forceful, medical may not be there, Malat. But consent of 16 years girl doesn't matter, Malat.
No, that this court is aware of.
Malat.
Heard Mr. A.K. Gupta, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned APP for the state, as well as your name, madam? Huh? B?
Sharma, B. Sharma.
Sharma, B. Sharma. And also as well as Ms. B. Sharma, the learned amicus
No,
curiae.
not amicus.
The learned counsel appearing for the respondent number 2. This is an application, you write those, it is an application, so and so. An FIR was filed on 12/8/2025 by the informant before the Lekhapani police station, alleging that on 11/8/2025, her daughter, aged about 15 years, went to her friend's house, and on the following day, at about 8:25 hours, her daughter called her and informed her that she had gone to Jagun, full stop. It was stated that the informant went to Jagun to get her daughter and brought her home. Subsequently, when questioning, her daughter revealed that the accused applicant, a resident of the same locality, had taken her to a hotel in Jairampur, wherein both had both had engaged in physical relationship. Full stop. Next, on receipt of the FIR, Lakhipur Lekhapani PS case number 53/2025 under section 65 1B and S 2023, read with section 6 of POCSO 2012 was registered against the accused applicant. After investigation, police, when was he arrested?
On my lord, 13/8/2025.
The police, next line, array line, the police arrested the accused applicant on 13/8/2025. After investigation, the police filed the charge sheet, against the accused applicant by charge sheet number 54/2025 under section 65 1 BNS, read with section 6 of POCSO Act. The learned counsel appearing for the accused applicant submits that though charge sheet has been filed in the instant case, that the charge has not been framed against the accused applicant as yet, and trial has not proceeded at all due to the vacancy of the post of Special Judge POCSO Tinsukia. Full stop. He submits that till date nothing has progressed in the instant case. In addition to the aforesaid submission, he submits that the girl who's alleged to be 16 years is a girl of 16 years, can understand the consequences of going with an adult person to a hotel, and she went voluntarily. Therefore, the conduct of the girl should be also taken into consideration while considering this instant bail application. Full stop. He further submits that the medical report submitted along with the FIR goes totally against the prosecution story, as nothing incriminating and or no evidence of any sexual intercourse was found in the medical report submitted along with the charge sheet. In view of the aforesaid, the learned counsel prays that since it is submits that since it is uncertain when the trial will be started, and the accused applicant has already been languishing in jail for more than 6 months. At this stage, he should be allowed to go on bail. Par contra, the learned APP appearing for the state submits that there are many incriminating materials against the accused applicant, and therefore he opposes the granting of bail at this stage. He further submits that the statements of the victim girl as well as other witnesses make it clear and points a finger clearly towards the guilt of the accused applicant. Full stop. The learned amicus, the learned MSB Sharma, the learned amicus curiae, on the other hand,
Counsel.
has oh, sorry. Mr. Bishrama, the counsel appearing for the respondent number 2, has on the other hand submitted an affidavit before this court, which is shown by the informant, wherein it has been specifically stated that the FIR was in fact lodged due to some misunderstanding and confusion immediately after the occurrence of the alleged incident. Full stop. It was also stated in the FIR that that she doesn't have any objection if this court allows her to go on bail, full stop. This court has heard the submission made by the respective, submission made by the counsel appearing for the respective parties, as well as has perused the materials available on the, in the TCR, which is produced before this court. This court has specifically taken into consideration the medical report that has been submitted before, that has been attached to the search sheet filed in the instant case, as well as the affidavit, that has been produced before this court. Another important factor that this court has considered considered while considering the instant bail is the absence of the presiding officer of special judge, special court POCSO, Tinsukia, since September 2025 till date. Full stop. Considering all these aspects of all the aforesaid factors, and also considering the fact that the accused applicant is also a relative who is aged at 25 years of age. This court is of the considered opinion that the privilege of bail should be granted to the accused applicant at this stage. Accordingly, it is directed that the accused applicant should be released from jail immediately on furnishing of a bail bond of rupees 50,000 with a surety of like nature, subject to the satisfaction of who will be there now?
There the learned additional session judge come special judge POCSO Tinsukia. He is taking as an in charge, my lord, all the cases, whatever.
The cases are, but
No effective orders if the bail applications or any other.
okay,
miscellaneous orders.
right, to the satisfaction of additional session judge
Learned additional session judge come special judge POCSO Tinsukia.
Tinsukia, you right, huh? Subject to the following conditions. I'll put some conditions because it's a POCSO matter. So we'll put some conditions. In view of the aforesaid direction, the instant bail application is disposed of as allowed. Yes. Yes.
38 hearing is,
38.
38.
Yes.
But matter is fixed at 2 minutes. So, I have some difficulty now, and my friend is, so can
Okay.
it be, my lord, on Thursday, my lord?
Thursday.
It's a small matter, my lord, I think.
Okay. Nice. I heard Mr. K. Agarwal, the learned senior counsel. So senior counsel appearing for the petitioner submits that he has some difficulty to conduct the case today. Therefore prays for a short accommodation. Prayer is allowed. Let the matter be fixed on 12th. Fixed on 12th. You please intimate the other side. Oh, he is there. Mr. A.K. Datta, appearing for respondent number 1 and 2 is also present.
Right, please, your lord. If 483 application for bail, regular bail, my lord, POCSO is involved here, my lord. Therefore, service of report is what?
They have taken steps only on 29/1, my lord, as per office note, my lord.
So we'll wait for some time.
My lord, yes.
Short date may be given, it's for Kamrup Metro, my lord. Another date will be required. Next week, any date, my lord. 17 or 18.
Heard Mr. P.M. Ahmed, learned counsel for the petition accused applicant. Also heard Mr. K.K. Parasar, learned APP for the state. Yeah, TCR or case there?
TCR received.
Receipt, my lord.
What is not received? Oh, this thing, respond number 2.
Service.
The office note dated 7/2/2026 reveals that reveals that the scanned copy of the TCR has been received. There is no report of receipt of notice by the respondent number 2. Let the matter be fixed on
17 or
18, Malad.
18th. 18/2/20.
Item 44 and 45.
All will application.
May I please your lordships? The 43 wait, against the application lordships. 58, 59 today is 59 days,
59.
lordships. 60 days is the mandatory period lordships.
59 days.
59 days lordships. Today is 60 days is the mandatory period lordships. The gist of the case as per the FIR, FPS 10 lordship is that the secret information was issued by the Demo police station lordships and secret information regarding the transportation of cattle lordship. And as they have conducted a NACA checking lordship and 4 numbers of vehicular intercepted lordship and recovered total 45 numbers of cattle lordship. In this case, 4 numbers of the petitioners before lordship, they are the driver lordship. They are the driver lordship out of the 4 vehicles. Item number 21, there are 2 petitioner lordships. They are the driver of the vehicle at page number 11 and
Driver of the vehicle, but how many vehicles?
4 vehicles.
4 vehicle lordship. So the 4% before lordship now. In item number 21, there are 2% lordship. I have annexed also the vehicle registration certificate at page number 11 and 12 lordship.
Mr. Parasar?
All length of detention, Malad. All are drivers, Malad. All statements are.
Okay, heard Mr. T. Chetia, the learned counsel appearing for the accused applicants. I also heard Mr. K. Parasar, the learned APD for the state. Decision application under section 483 of BNSS 2023, praying for granting bail to the accused applicants in connection with Demo PS case number 86/2025 under section 303 in bracket 2 BNS, 2023, read with section 11 in bracket 1 in bracket small a of the Prevention of Cruelty to Animals Act 1960, read with section 13 in bracket small a, the Cattle Preservation Act 2021. An FIR was lodged before the officer in charge Demo police station alleging that on 12/12/2025, based on secret information while doing NACA checking in the morning hours at under the jurisdiction of Demo police station, the police intercepted 4 vehicles bearing registered number AS-23-CC-4669, AS-03-CC-5844, AS-03-CC-5803, and AS-01RC-4846 respectively. Wherein 45 numbers of cattle were being transported in a highly congested and unsafe manner in clear violation of the Prevention of Cruelty to Animals Act. Full stop. It was also alleged that the drivers of the vehicle could not produce any valid documents for transportation of those cattle. Next para. On receipt of the FIR, the police registered Demo PS case number 86/2025. Under the aforementioned sections. Full stop. The learned counsel appearing for the petitioner submits that the vehicle, the owners of the vehicle are two different persons, two different persons, and the accused applicants are only the drivers of the vehicles. He further submits that the accused applicants are behind the bars for last 59 days, and they are no way linked to any illegal transportation of the vehicle, being only the drivers of the vehicles. Full stop. In view of the aforesaid and taking into account the length of detention, the length of detention they have already gone through, the accused applicants should be granted bail at this stage. The learned APP, and on next para, the learned APP has also submitted that that the charge sheet in the instant matter has yet to be submitted, though already 59 days have crossed. Full stop. Next para. Taking into account the length of detention of 59 days, wherein the mandatory period for the offence is alleged is of 60 days. This court is of the considered opinion that at this stage the accused applicant should be granted bail accordingly. It is accordingly it is direct with the accused applicants shall be released forthwith on furnishing of bail bond of rupees 20,000 each with a surety of like amount to the satisfaction of the which court?
Learned CJM Sipsagar office.
To the satisfaction of the learned Chief Judicial Magistrate Sipsagar, subject to the following conditions. You can take the conditions from there. 3 conditions. In view of the aforesaid direction, the instant bail application is disposed of as allowed.
Respect item of 45 and 44, same order.
Same only.
They're all driver.
All drivers.
Driver also.
45 council is.
Huh?
45, the number 45. Council is MAN. 44.
44.
Council is MAN.
44 council is different. And
45
for
is same.
45 same council and same order. Huh?
All right, sir.
22.
22 मतलब charge sheet submitted.
Well, even if charge sheet is submitted, my lord, your lordship can consider the matter.
No, but you go and appear there.
Well, then give me protection, but I am behind the bar.
You go and appear.
But your lordship has granted so many cases, my lord. In a charge sheet case, bail has been granted. Well, what is my offense, my lord? Kindly peruse it. Main whole thing is accused number 1. Even in charge sheet also, if your lordship peruse that, your lordship will find.
There is a proper deposit. There is a forum charge sheet has been submitted. The charge sheet will be perused. Materials will be seen and they will be given.
No, it was rejected, that's why I have come.
No, it will be given.
Rejected.
It's
Kindly
a.
peruse. Whole allegation is accused number 1. The boy and the girl are in love, my lord.
That always happens, Mr. Biswas. But the boy cheats the girl. That's the problem.
Yes, I am not for him. Other 2 persons, we enjoyed the DJ dance in the same hotel. And we have been entangled, my lord.
No, you appear before the.
My lord, then peruse the CD, my lord. What allegation against me, my lord, kindly?
Where is the CD? Already charge sheet.
A scan copy may be called for, my lord.
No. At this stage, you go there and like if there is something wrong, then you can always approach.
That I can come, my lord, before your lordship. But on the face of the record, it shows that accused number 1 is the main culprit. I am not for him. Other 2 persons, they have no role. They simply went to the function to show the DJ dance in the same hotel. Even the learned special judge, when rejected my pair, there also mentioned that Swarup Das is the main culprit. And Swarup Das is guard and the victim is they are in a love relation. moreover 36 is not complied, your lordship judgment is there. There is the attestation of any witness or the family member, which your lordship has held mandatory and violative to fundamental rights, Article 21. I have annexed the 36th memo also of arrest, my lord. Your lordship will not find anything that they have followed. 36. Page 26, 27, kindly peruse, my lord. Your lordship will find. There is the endorsement of the accused or the independent witness of the locality or family members, which is the requirement of law.
Page number 29 and 30, my lord, the code below, when they were perused, my lord, on 11/11/25, mention, my lord.
Even in forwarding report also, there is nothing against us. Only accused number 1.
See, there are materials against other persons also.
But we are not involved.
See, I mean, you are not involved. A sexual offense was carried on in a room, in the same room, both of you were present.
This is exaggeration.
Both of you were present.
Well, in I also.
This
I
is
have
on
also
record,
taken
this is on
On
record,
rent one bed, my lord.
this is on record.
That is maybe. But whether we have participated in these things of offense, my lord, not at all.
Participate, it means whether like you need to go and touch somebody.
No,
Your being there is also a participation.
My lord, we enjoy the dance, my
You
lord.
enjoyed the scene.
My lord, I do not know unless you lordship
No, that's what you are saying, that you enjoyed the scene, staying there.
Not enjoying the scene also.
Then,
My lord, in the forwarding also there is no.
so you insist then like I will, I mean, I will dispose it upon merits.
Yes, my lord. We'll again count that, my lord, to your lordship.
Okay, without this thing, we'll dispose it of. Okay, heard Mr. S. Biswas, the learned counsel, appearing for the accused applicants. But in this case, Mr. Parasar, I mean, a notice was issued to respondent number 2, but nobody appeared till now.
In the agreement, my lord, amicus could be appointed. Your lordship is too hard.
No, charge sheet has already been filed.
Charge sheet, that is, I appreciate, my lord. I agree with your lordship. Then in the agreement, your lordship give a direction to consider our prayer in the court below. Palpably 36 is before your lordship, not complied with. Your lordship's judgment. Your lordship's judgment has been endorsed by other coordinate bench also nowadays. I have placed the judgment just now to court number 8. Your lordship's judgment.
But that can be,
Your lordship can dispose of the direction to the court below to consider whether 36 has been complied with. But on the face of the record, it is there. There is no endorsement of any person.
I think all these things, my lord, bail petition can be moved before the court below, and if it is not there, my lord, after verification of the CD,
you go there, Mr. That will be better. You
If
go,
your
you
lordship
go
feels
there
that
or
is
there. You may be having a case. You may be having a case. You may be having a case. It's better you go there.
If your lordship kindly give a direction to
Then
consider it.
direction, no direction, but you always have a liberty to go there once such it is filed. You can avail that option. You will have another forum. That's better, I think. Mr. So-and-so, the learned counsel for the applicant. Also heard Mr. K.K. Parasar, learned ABB for the state.
96 days, my lord, behind the bar.
Yes, that's what I'm saying. I mean, you may have a case there. I mean, charge sheet has been filed. I mean, if there are no allegations against you as such. In the FIR, there is nothing, but there's something has been revealed in the statement later on.
When the charge, forwarding report also do anything against me.
No, see, I mean, it seems, Mr. Parasar also can have a look. See, if in the FIR, there was no such allegations.
my lord.
But in the 183 statement, there are certain
No,
allegations.
do not have
And the story in the FIR
It is not before the lordship we are
see,
162.
story in the FIR is little bit different than the statements that has been made in 183,
well.
correct? There are some these things, because in FIR, it's a different story, little bit of different
Yes.
story.
And my lord, we must have,
Anyways, like, you
we should
go and
encourage a girl of 17,
you go
18,
and
17 years.
years.
He went to with the boy, with his boyfriend to enjoy the dance, and there all these things happen.
so an FIR was one FIR was lodged on 11/11/2025 by the informant alleging that on 9/11/2025 in the evening, his minor daughter of 16 years of age went to her friend's place, but she did not return in time. Full stop. Therefore, he inquired about her whereabouts, and on 10/11/2025 in the morning at 11 a.m., his daughter returned home and intimated that on 9/11/2025 she met her friend one Sarup Das, alias Saurav, who picked her up in his scooty and took her to Silchar Boreal View Hotel. It was alleged that she, along with her friend and the accused applicants, enjoyed a leisure night there, and after that returned to the hotel room. It was alleged that the aforesaid Sarup Das, with an ill intention, took his daughter into the bathroom and tried to outrage her modesty, but by disrobing her. Full stop. It was alleged that when she protested, the aforesaid Swarup Das, alias Saurabh, assaulted her and broke her mobile phone. It was alleged that she somehow came out of the bathroom and slept in her bed. However, the aforesaid Swarup Das and Swarup Das alias Saurabh entered into her entered.
I came to know girl is a major.
No, love doesn't mean that you'll do
No,
something of this.
To the extent now, why such type of things happen, my lord? Why you accompanied to a
No,
device?
please, don't make this kind, don't
16
this
years
kind
for
of,
father.
no, don't make
It is
this kind
20
of
years
things.
for me.
Yes, Mr. Bora.
In these matters, 187 days today.
Mr. Arunav was appointed as.
Yes, just before that, he just informed me and that he is not well so much.
He's not well.
Not well.
Then we'll put it up for some other day with a short date. Heard Mr. BP Bora, the learned counsel appearing for the accused applicant. Also heard Mr. KK Parasar, the learned APP for the state. It is submitted before the bar that the amicus curiae appointed in the instant matter, namely Mr. A. Foucault, the learned counsel, is not keeping well. Therefore, a prayer has been made to list the matter on a different date. Accordingly, let the matter be listed on when?
Not to any day. Except 17.
He's not keeping well means what? Normal.
Normal, yes. Just fever, little fever from it.
Then we'll fix it on next week sometime.
18.
Huh?
18.
There are two applications over.
Yes.
Yes.
46 and 47.
One bill application, one
AB.
anticipatory bill.
Okay, so we'll fix it on it. Fix the matter on it.
This case is by the 3094 BNS, Robari.
309?
Right. But in my understanding, my kindly see, but today is 61 days, my lord. Actually, you kindly have looked to my 309, your loss is surplus.
309 BNS.
BNS, man.
This is 90 days.
May I hand over my.
No, it's coming. It's coming.
Your loss kindly.
3094.
3094. Kindly see, my lord, you have two part by 3094. One is, if it is in highways, then it is life sentence, madam. 14 years. Kindly have a look to my lord.
3094.
Nine four, my lord. Whoever commits robbery shall be punished with imprisonment for a term which may extend to 10 years, and is also be liable to fine. And if robbery be committed on the highway between sunset and sunrise, imprisonment may extend to 14 years. Now kindly see the FIR, my lord. Otherwise, my all co-accused already granted bail, madam. Not named in the FIR, page 10. Respected back to study, yesterday on 112, it account so-and-so in the light, a group of so-and-so came in our company depot situated inside the graduate premises near Golpaga. Sharp weapons assaulted. Two chowkidars were so-and-so. So it was in the depot, by the way, situated the graduate premises, not in the highway. And nothing more from us, the person from whom is recovered, he already granted bail by the court below.
So when you were arrested?
Arrested, madam, on 12/12/25.
You have come for how many people?
61 days today, madam.
Hmm?
61 days.
61 days.
Yes.
You have and you have come for 2 persons.
Yes. Both are brother-in-law, madam.
Hmm?
They are both are brother-in-law, madam. They are having also dump of scrap materials. In the-
51 days.
Yes, 61 days.
61 days.
61 days.
61.
61 days.
Marksheet not filed. Otherwise also, madam, I am entitled as per section so and so, madam.
So,
Within the premises, madam.
so it will come under 10 years.
10
thing.
years. Extend to 10 years.
Extend to
60
10 years. Extend to 10 years, then
60 days.
60 days. Yes, Mr. Porasa?
Lordship. That is to Lordship, 60 days punishment, but the materials are dear Lordship.
Hmm?
Materials are there.
Matter said that, but statutory provision is there. See, I mean, FIR specifically says
From
that
there go down.
it's not,
the
not in the highway.
Yes.
Had it been somewhere beside the highway, there is nothing like that.
Because they enter into the warehouse and they tied up the person with the
No,
bed.
that is there, that is
Thereafter,
there.
Lordship, they have.
I'm not on merit now, madam. Otherwise, merit nothing recovered from me, madam.
So, I mean, if it is below 10 years, up to 10 years, then 60 days. Then already 60 days are over. Now, Mr. H.R.S. Chaudhary, the learned senior counsel, assisted by
Yes, Ahmad.
Ahmed, the learned counsel, appearing for the accused applicants, also heard Mr. P.S. Locker, the learned APP for the state. This is an application. Application. An FIR was lodged on 2/12/2025, alleging that by one Chumbru Alda. Alda is who? Is he the police person? or what?
He is the, my dog. Manager, madam.
Okay, one Chumbru Alda alleging that on 1/12/2025 at around
Excellent.
2:30 AM in the night, a group of around 14-15 dacoits came to their company depot situated inside the railway premises near Gwalpara, armed with sharp weapons and assaulted the 2 chowkidars of their company and thereafter looted 6 bundles of electric copper wires which were being used by their company in constructing railway lines. It was also alleged that one of the chowkidar, namely Ratneswar Rava, was critically injured. Full stop. On receipt of the FIR, the police registered the Gwalpara PS case number 221/2025 under section 309(4) of BNS 2023. Next, the Mr. H.R.S. Chaudhary, the learned senior counsel, appearing for the accused applicants, submitted that the instant case cannot be, could not have been registered under section 309(4). Has submitted that though the case has been registered under 3094 of BNS 2023, the instant case will fall under the category wherein the punishment has been provided for rigorous imprisonment for a term which may extend to 10 years and not for 14, not up to 14 years. Therefore, he submits that in the instant case, since the accused applicants have already spent more than 61 days inside the jail, the default period prescribed for the offense as alleged to have been committed has already expired. Full stop. In view of the aforesaid, he submits that the accused applicants are liable to be released under on default bail, full stop. Next para, Mr. P.S. Locker, the learned APP submits that the charge sheet has not been filed as yet, and 60 days, mandatory 60 days are already over. Mandatory 60 days is already over. Next para, considering the aforesaid facts and having found out, having seen that the case that the offense as alleged in the FIR clearly falls under the category of offense wherein the punishment has been provided for rigorous imprisonment for a term which may not extend to 10 years, and therefore the mandatory period is 60 days in detention. This court is of the considered view that the accused applicants are liable to be released on default bail. Full stop. In view of the, therefore, it is directed that the accused applicants shall be released forthwith on bail on furnishing of bail bond of rupees 30,000 each with surety of like nature to the satisfaction of
CGM Golpara.
CGM Gwalpara, subject to the following conditions. 18 conditions are set at a deed level. In view of the aforesaid direction, the instant bail application is disposed of as allowed.
Mandatory 60 days because Lordship, it is not, it was done, the offense was occurred within a railway premises.
Sorry?
Mandatory 60 days, that my submission, Lordship, because Lordship, it was the offense was occurred within a railway premises.
That I have stated there. I mean, in the factual thing, I have stated.
Lordship, this petitioner is in interim, CD not be received.
Sorry, Malad, CD not received today, Malad.
Interim may be continued, Lordship.
Interim is there, Malad.
Yeah, Mr.
Noor
Your name?
Jamal, N. Jamal.
And heard Mr. N. Jamal, the counsel appearing for the accused applicant. Also heard Mr. K.K. Parasar, the learned APP for the state. CD, the instant case is yet to be received.
6-3.
Let the matter be fixed on 6-3.
6-3-20.
6-3 is too far. Will you require it much? No, I can give you, but like whether you will require it much. AB application.
AB, Malad. 26 to Malad. 26 to Malad.
26-2. AB application, that's why I'm saying.
Malad.
Interim order so passed earlier, shall continue till the next day of stop.
24.
Also, can I say FIR page 11, madam?
Hello, item number 24, 26, 31 and 32, my lord. Maybe taken up together arising out of the same affair, my lord.
Same affair.
Oh, oh. 26 was same, maybe.
26,
All are there, all are represented.
26, 31 and 32, my lord.
Mr. Boro, repeat again.
24,
24,
26,
26,
31
31,
and 32, my lord.
32. 24, Mr. Chaudhary is
Oh,
appearing. 26, Mr. Mohanta. And 31 and 32? 32? You are appearing 32. Okay.
The total 27 my lord person named in the FIR. Huh? 27. Yeah. Now a group class, my lord. Page 11 in my petition, my lord, page 11 in the FIR.
So who are named, who all are named in the
I
FIR?
am here, my lord, here you also will find.
So you are Abdul Ghaffur.
Yes.
Abdul Ghaffur is named.
Abdul Ghaffur,
Abdul
you
Ghaff-
also will find. accused number 13.
Huh?
13, page 13 in my,
Abdul Ghafoor is at page 13.
page number 1. And
Page 13, number 13.
yes,
Ghafoor or Ghafoor Ali or Abdul Ghafoor?
Abdul
Same.
Ghafoor alias matter, they have written the FIR matter, the correct name is Abdul Ghafoor. madam.
Okay, then you are
Then
there.
14, then 14. Amjad Ali, page number 2.
Acha, Amjad Ali, yes.
Yes,
So both
Then
of you are,
petition number-
both of you are named in the FIR?
yes.
Okay,
All are 9, madam.
okay.
Then accused number TN 4.
So what has happened actually? So went to Rokwa and is cultivating horticulture.
Yes.
Like land is at the land measuring 25 acres. In morning at about 10 AM, they were showing the seeds in horticulture. The below mentioned persons carrying with dowel at in their hands attacked. They attacked the above noted persons and caused serious injuries to all persons. Among them, my uncle Monwar Hussain and maternal uncle the hospital and the prison would like to declare both dead. Is dead. The risk of medical and treatment. To save the first there is injuries. Yes.
Now, madam, kindly see my paragraph 7 of my EA, madam. The facts I have given, madam. 7 of my petition, madam, page 5, paragraph 7. This should give the true picture, madam. Also. Informant party is the aggressor, madam.
So one person from your group also died.
Yes, 1 person died from this side, other side 2 person died. Informant party. So initially it is about.
But you didn't file any FIR.
that is not filed on the understanding by them, my lord.
But they have filed it.
Yes, they have filed
Hmm.
it there, my
But
lord.
you were aware that they have filed it, but still you haven't
That's
filed.
subsequently, my lord, because
Because see, they have filed immediately. On
They
the
filed
next,
immediately.
immediately. And he must have been aware
no,
that
so far
FIR
we
is
are
filed.
concerned, my lord, our case, we do not belong to that village, my lord. We have land in that village. So areas, my lord. Fight is been true for regarding land, my lord. And so far, we are concerned, we have stated category that we belong to 5 kilometers away from that place, my lord. And the whole people of the village might have been implicated here, 27 persons, my lord. All the villagers almost, my lord. Including person, we are not there at all, my lord, 5 kilometers away from that place. And one person died, my lord, that automatically that case might have been registered also by this time, my lord. Anyway, my lord, so far I think, my lord, it is a case only because of this, my lord, because there are two villages. One village, they have filed the case giving the name of the almost all the leaders of the whole villages, my lord.
So again, there will be fight if you are released.
Till today, no fight has been taken away. We are on heavy, my lord. Nothing happened, my lord. Nothing happened till.
You are appearing for somebody. Informant. What is your contention now? Hmm?
They are being paid because they are now far away from the police hand, my lord, and once they are released, my lord.
But you are also a big group. Hmm? Then? But you are not a big group. How many people are there? How many people? Hmm?
They were just working, my lord, and these accused people, my lord, they came up with equipped with Lucky Tower.
No, how many people are working there? So you were also 9 people who were working. At least 9 that you have already mentioned. You said 2. We 2 were working.
Now, in my submission,
So how many were there? That's what I'm asking. How many were there?
not aware. Exactly.
You were not aware. You haven't gone through the FIR? In the FIR that, I mean, you are going through the FIR now? Huh? What, Mr. Counsel? You are coming to defend your clients and object to the bail, and you are not aware how many people were there in the FIR. Now you are reading it now here. Yes, Mr. Mon.
My lord, I just point out one thing, my lord, my lord, senior can put it, my lord. There is a clash between villages of 2 villages, my lord, regarding a very plot of land, my lord, in short area. And sometimes they are, my lord, cultivating, and sometimes other people are cultivating. And then, my lord, there's some at the time of, my lord, and that particular day at 8 o'clock, my lord, some incident was happened, my lord, because of the, my lord, regarding cultivation of that particular land. Now, my lord, one side, my lord, filed an FIR giving the name of, my lord, all the male member of the other village. That's why your lordship kindly see there are 27 names, my lord, and column number 20 and others. So already, my lord, in this case, as reported by my learned friend, my lord, 5 persons were arrested. Subject to my lord correction 1, I came to know, but serial number 1 is already been arrested. Others are all, my lord, AB.
5 persons are already arrested.
Probably 1 person arrested, I came to know, but from today I came to know that another 4 is arrested. So total 5 persons were arrested. So now, my lord, your lordship kindly see over. I am concerned. I am serial number 5 in my petition, my lord. Maseb Ali. Serial number 5 of the, my lord, FIR, my lord.
Serial number 5 of the FIR, okay.
FIR, my lord. Maseb Ali. So I am staying in a far away, 40 kilometer away because of my service there. Other male member of my family also, my lord, name here there, my lord. I am not representing them, my lord.
But you were aware.
My lord, I am there.
You were away.
I am away. I am staying in a different place. Para 6 of my petition I have stated. And on that particular day, I am the headmaster of a school, and I was in the school at that point of time because there is school managing committee meeting was going on at 9:30. So I have annexed that, my lord, and I am, my lord, I was granted interim, and I have my statement has already been recorded.
You have been given already interim.
Interim, my lord, and my statement has been. I am a single teacher headmaster, my lord.
Okay,
school.
your cases then little,
My
will be little bit different.
My lords.
Since interim has been granted.
Question of bailiff that I was not there, but because of, my lord, I am the village, that my original village is there, my lord, and my other family members' names are there, my lord. I am not representing them, my lord.
So
that
your
is-
case is fine. I mean, you have been already given interim and
And I am
you
already
are a
my statement has
headmaster,
been-
you stay away and like away from the spot as well as, yeah, I mean, you were
Para
in a
6 of
meeting.
my
You were in a
petition.
meeting, this one.
My
Okay.
case is para 6 of my petition.
Okay, and any other persons? We'll hear you, miss, I will hear you.
In item 31, I am in.
Item 31, yes.
Yes. Here in the 3-person, your lordship, and the accused number 6, your lordship.
Accused number?
Accused number 6 is the elder brother of the
No,
present.
no, your accused numbers, which are the accused numbers in FIR?
In FIR.
Hmm?
I mean the item number 26, he is the elder brother of the present petitioners.
Item number 26,
He is the elder brother of the present petitioners.
elder brother. So headmaster is your elder brother.
Yes.
Acha, oh, and now you stay in a different village.
Yes.
You stay in a different village.
Yes.
Stay in a
Place
different
of
place.
occurrence-
No, I mean, how many persons are there in item number 31?
In item number 31, 3%.
So if, I mean, 3 persons, then like how all the 3 persons can be brother? All 3 are brothers?
Yes.
Huh?
Yes.
Acha. Okay, all 3 are brothers.
All the family members in that particular village, my lord, their name.
Okay, all 3 of you are brothers and like your elder brother is the headmaster. Okay. And yeah, what you were doing at that point of time?
In fact, your lordship, here in the dispute is.
So headmaster was in the school, but you came to the spot.
No. We are from different villages, your lordship. And
You
the
came
place
to-
of occurrence is another
In a
village.
different place. But you came with Dao and Lathi.
No.
You did not?
No.
So where are you?
I have met specific environments that on that day we were not present therein. Here in the
But
dispute,
where were you? That's what I was asking.
we were some other place, your lordship.
I understand other place, but at that time where you were?
But
You-
I have
I
made a
mean, you were
statement
in-
only that we were not present therein. And
No other
the place
information.
of occurrence.
No, you
is-
don't have any other information.
And the place of occurrence is almost how many?
Okay, got
10
it.
kilometers far away, your lordship.
10 kilometers.
And the place of occurrence is under the jurisdiction of Golfara district, and we are the resident of under the jurisdiction of Dhubri district, your lordship.
Dhubri,
Yes.
but the bordering area maybe.
Yes.
Okay, and what about you? Yes, I mean, what is your case? You are appearing for, you are appearing for one person?
Yes, madam.
Ah, you are also resident of a different village?
Different village.
I mean, same village like all the petitioners, same village. And where are you at that point of time? Where were you at that point of time?
At the time, I'm not there, madam.
You are not there. Okay. I mean, Mr. Borua,
Yes, my lord. We have received the case diary, my lord, along with 2 postmortem report, my lord. Their cause of death is, my lord, hemorrhage, my lord. And my lord, their intestine, they have attacked the disease, my lord, in stomach, my lord. And as a result of, my lord, there are hemorrhage and, my lord, both the accused person died, my lord. And there are, my lord, 4 injured persons, my lord. All the injured persons sustained, my lord, grievous injuries, my lord. Now, my lord, as per the injured person statement, my lord, they have implicated, my lord, this accused person, my lord. I'll take up, my lord, first lordship, item number 24, my lord.
24.
In item number 24, my lord, there are 6 accused persons, my lord. 6 accused persons, item number 24, my lord.
Item number 24.
6 persons
6
are
accused
petitioners.
persons. 6 petitioners, my lord, accused.
6 petitions.
And they have,
Yes.
and they have implicated, my lord, the injured person, my lord. They have implicated, my lord, Amjad Ali, that is petitioner number 2, Saha Alam, petitioner number 3, and Guljar Sheikh, alias Guljar Hussain, that is petitioner number 4, my lord.
4 persons.
3 persons.
3 persons.
3 persons.
And other persons are not implicated.
Our other person, my lord, not implicated, my lord, although they have implicated, my lord, but their injury report I have not found, my lord. And Abdul Gopur, my lord, probably he is arrested, my lord, as stated by my learned senior friend.
Abdul Ghaffur is arrested?
No, no.
No, he's not arrested.
None of the 6% arrested. None of.
And I mean, there was a statement that 4 persons were arrested. They are still inside the jail. What?
Yes, my lord.
Some 4 persons were arrested. It was stated.
There are so many petitions, my lord, that is, I was having difficulties as well. But arrested accused persons are my lord, Rokibul Hussain, my lord, then Kitab Ali, then Bahar Ali, my lord. These are the 3 I have got it, my lord, from the case diary. Rokibul.
So let them, Mr. Borua, let them cooperate with the investigation.
My lord, their injuries are, my lord, grievous, my lord. Even, my lord, 183 statement has been recorded, my lord. 183 statement also they have implicated, my lord. Who has inflicted the, my lord, injury caused by, my lord, Dow, my lord, in the head of the deceased, my lord. They specifically mentioned, my lord.
See, these are group classes, right? It's a village class. It's not a typical intentional, fight wherein
Maybe,
like,
my lord,
something has
but they
happened.
cannot, my lord, kill it.
See, there was a village class happened, it was in a land, and all these people, all these families are there, and en masse they have named people, right, from a village. There are people who have been, who are not there also, they have been named. So you see all these things.
So the question is that, my lord, when
Then-
there is a specific materials in the case there, my lord, so how can Lordship can, my lord, come to a conclusion that they let them maybe allowed to appear before the.
What Mr. Borua you are saying, I could not understand what you are
The
saying.
question is that,
Now,
madam,
if there is a material, specific material, then bail cannot be granted.
No, bail can be
No,
granted.
bail cannot be granted, or what? You tell me that.
No,
Now,
bail-
don't make this kind of statement.
No, madam,
We'll
question is-
consider this, and we will consider these the materials, and we'll see pros and cons, then the bail will be granted. And why you are saying that there is a specific
The
material?
question is that, madam, 4 injured persons, my lord, who sustained grievous injury, my lord.
Correct.
They have implicated these all accused persons.
Then
my
what
lord.
about other people? Other
And
3
they
people?
have specifically mentioned, my
Now,
lord.
what about other 3 people that you have not been, then that they have not been implicated? Then there are many people who have not been implicated.
Yes, my lord, that is why, my lord, I am only
That's what I'm
referring-
saying, that
I'm
that
only-
then you do not make this kind of submission that there is a material, then bail cannot be granted. The bail can be granted on many considerations. It's not only on the basis of, the material there.
Granting bail is lordship discretion, my lord.
There are
My humble submission is
lot
that,
of
my
many
lord,
things, many things has to be considered,
my
Mr.
humble
Borua.
submission is that, my lord, since the injured person, my lord, they have specifically mentioned, my lord, the person who has cut the legs of the, my lord, deceased, my lord. They have specifically mentioned, these are the person who has cut the leg of the deceased, my lord.
Let's see the statement, how statement is being made.
Yes, my lord, lordship may kindly peruse, my lord.
No, you
That is
read,
why I-
read out.
My lord, I am reading the relevant portion, my lord.
You read out the statement. Whose statement is this?
Carlos, this is the injured person, my lord. His name is Azad Ali, my lord.
Okay.
এতিয়া গুলজাৰ আলী আহি ডেগাৰেদি মূৰত কোব মাৰে।
Mm.
হামজাদ আলীয়ে পিঠিত লাঠিৰে কোব দিয়ে
Mm.
আৰু মোৰ দেউতা মাটিত পৰি যায়। মানে দিছ এফেক্ট টু ডিচিজ পাৰ্চন, মাই লৰ্ড।
Mm.
এতিয়া চাহিনুৰ আহি ডেগাৰেদি মূৰত আৰু এটা কোব দিয়ে।
Mm.
তাৰপিছত জাহানুদ্দিন, মাই লৰ্ড, হি ইজ ওৱান অফ দি পিটিচনাৰ, মাই লৰ্ড, আহি মোৰ দেউতাৰ ভৰিত জগাই ধৰে।
Jahanuddin.
জাহানুদ্দিন, ইয়েছ মাই লৰ্ড। জাহানুদ্দিন আহি মোৰ দেউতাৰ ভৰিত জগাই ধৰে আৰু কয়,
Jahanuddin is not prisoner. Well,
Jahanuddin he is a, my lord, item number, my lord.
okay, Jahanuddin is item number 32.
Yes. My
Yes.
lord. Then ahi মোৰ দেউতাৰ ভৰিত জগাই ধৰে আৰু চাহালাৰে ঠেং কাটে, my lord. These are the specific, my lord, allegation, my lord, specific implication of the accused person, my lord. লগে লগে আবু সাহেব শাহ আলম আসাদুলে ডেগাৰ আৰু কুকৃতি ভৰি কাটে। তাৰপিছত মইনাল আৰু মইচান আহি পিঠিত লাঠি দি কোবাই।
Who are those? Joinal.
They are the petitioner, my lord. They are the petitioner in item number, my lord. In item number 31, my lord.
31.
31, my lord. I'm sorry, my lord, not 31.
Not 31. 31 is
Joinal আৰু মইচান।
39 Akel Ali Mohammadul Haq and Abu Sayed.
My lord, Doinal Morsad is not before this. I'm sorry, my lord.
No, so you,
So-
no, so you give me the specific names,
Yes,
where those, this thing,
Yes.
those who have been specifically implicated.
Yes.
Or
Thereafter, my
statements,
lord,
statements.
Sattar Ali Prothome Musab Master Ahi. That is my lord, this is the Musab Master, my lord, item number 26, my lord.
Item number 26.
26, my lord. Then my another senior friend is appearing, my lord. Yes, my lord. Musab Master Ahi Lathi di Pithit Kup diye. my lord.
So the headmaster,
Headmaster. my lord.
headmaster came in like,
15 kilometers away.
This is the injured statement, my lord.
okay, let me decide. I mean, let me see. I'll go through the CD, then I'll see that what are the implications of
My
it.
lord, lordship, there are various flag marks, my lord, including a post-mortem.
How will I do it
Only
now?
lordship may kindly go through this flag mark. It will be convenient, my lord. Otherwise, my lord, I have prepared a my lord, list of all the my lord, a person, my lord, who has attacked.
Then you give me that now, then. No?
Yes, my lord.
Yeah, then you do one thing now. Can you do little bit of work for me? I mean, petitioners' names you have
Yes,
already. And like, those, the petitioners against whom some implications are there.
Yes.
Some allegations are there, or specific statements are there,
Yes.
that you can,
No,
point
that
it
only
out.
I have flag mark, my lord, with a star mark, my lord. That lordship, only lordship may peruse those statements.
It will take some time, Mr.
My lord, only,
Chaudhary.
this one is your lordship knows, my lord, and friends, and headmaster, 15, we are 20 kilometers away, my lord. How I came.
Well, let's say, I mean, there are
All
some,
the male persons of the.
some materials are there, some materials are there. Some
But we
materials are
looking
there.
to see 27% name, and they have included only 3 to 4 persons, man. That also going to see, man. Arrest also 5% arrested, man. Who are those persons?
The police is searching them, my lord. That is the investigation is pending.
Figures of it.
It will definitely.
Okay, you can write the names, I take the names. This,
Starting from 24, man.
24, or else, I mean, one of his juniors can give the name, and like respective councils can give the
Yes,
name,
council.
give the names. And you are Mr.? So you are opposing this, right? Any other things you have to? Any other submissions you have? You are opposing the bill.
Obliged.
You are appearing all the matters.
Only 9.
Item 24. So he's only in 24. Huh? This one is in-
Twenty-seven and 28 are same affair. I mean 27, madam. Senior is 28, madam.
My lord, in both the case, my lord, interim order is there, they have appeared, their statement recorded, but thing is that, my lord, whether they are properly involved in the case or not, my lord, FSL is required. Now that FSL report is not available, my lord. May I pray, my lord, as they are already in interim, my lord, let the FSL report come, my lord. But they have, my lord, hold the signature of a person, my lord, and make document to get claim in the MSCT case, my lord.
Page 11 is the FI, madam. That signature part I have nothing to do with. Page 11, madam. In my petition 27, madam.
Page?
Page 11, madam. Signature part nothing to do. I'm an insurance investigator, madam, for the company. And it is based on suspicion, madam. The allegation, madam. Something may have been done, madam.
The Abhishek Bhattacharya AM is, I mean,
I am
yeah, Abhijit Bhattacharya. AM is my manager, assistant manager
Yes, then.
of this insurance company. Huh?
Gauhati. If lordship allows.
So, yeah, so there is a specific allegation against you. And who are you?
I am Pulok Ranjan Kolita, my lord. I am an insurance investigator in that company, my lord.
Insurance investigator. So in connivance, you, I mean, allegation is.
I cannot put up that claim note, my lord. It is not in my purview, my lord.
Hmm.
I can only submit that insurance investigation report, my lord.
Report he has submitted.
That, my lord, accident took place or not, I get the documents, I submit the report. my lord.
So, I mean, this, I mean,
Claim petition was there for get a MSD claim, my lord, but
forced my signature in our claims approval note.
yes.
That I have nothing to do.
So who,
Permits.
so, okay, no, 1 second. So, claims approval note has to be approved by one of the officers, right?
And yes, my
So one of the officers has to do it, and his duty is to investigate prior to that.
my lord.
So approval will be done by somebody, approval may be done by Mr. Bora's client, right?
No, lordship, I also don't.
No, no, will come up, will come up. So allegation is against you that, it may have forced by you, correct?
May have.
Huh,
That
that's
is
what,
the
the allegation, so.
Our suspicion.
So, but his case is there, I mean, he is an investigator.
Well, he has submitted the report. Malad. Otherwise, malad, because of this, malad, both the persons are in interim. Malad.
Hmm.
Or they have appeared also.
No, no,
Malad,
no, but
now-
his case may be different, his case may be
Malad.
different.
Why not? Because my sign is cannot be there.
No, because his involvement is not there.
Malad, yes, he has submitted the report. Malad.
He has submitted report, on the basis of the report, somebody has approved it. Allegation is only about the forgery, no?
Forgery of the
It's
signature.
not that like he has submitted a false report
No.
and the false report
False
was this,
report.
nothing like that. So I think we can allow him to go. But as far as him, Bora's client is concerned, we'll hear you. Okay, this one, I mean, we have heard you, we'll allow you. Your interim will be made absolute. And what about your Bora's client?
Yes, obligation. Lordship, I just come to page 21 of my
21.
21. On 13/9,
On?
on 13/9, on the given day, 32 cases were there
Yeah.
to be settled. The case concerned here is serial number 5.
Serial number 5.
Serial number 5.
Hmm.
Lordship would see the remark column,
Yeah, not settled.
not settled.
Hmm.
Now, this allegation could not have happened because it is not settled. Firstly. Secondly, Lordship would see, I am an officer. The settlement note contains 2 officers. Firstly, his signature, then my signature. I can only sign after his signature,
Whose signature?
the informant signature.
The claimants.
The informant.
the informant is who?
Informant is the branch manager.
Informant is the branch manager. Okay, informant signature has to be there, then your signature needs to be there.
Yes, Lordship.
Huh.
Because there was some discrepancy, the case itself was not settled. There was no loss caused to the company.
No, loss is different thing, Mr. Bora.
And Lordship, I have not forged it and I cannot forge it. I am just an officer. After him, I will sign it. And if both signature matches, then only. And most importantly, it is the party. If party is willing to settle, then only it is settled. Therefore, the case is not settled. Lordship, what has happened? Now, there was.
But your intention was there to defraud.
No, absolutely not. I have not done it, and it will be clear.
His statement he has denied. Malad.
Huh?
And I have been.
His statement is there. He has denied.
Yes, then, but like any other statement,
Malad, regarding
see,
that, malad,
about the Harry, claimant.
claimant, specific signature has been sent for FSL. Otherwise, claimant, suspicion. Claimant is
Lordship will kindly.
No, because like, see, he's signing means he has to be in connivance with the claimant, then only he'll get some money. Is there anything like that? See, if I understand properly, MSCT claim
yes.
is, report has gone. Now settlement will be done. And like, the allegation is that like while settling it, he has forced the signature of Mr. The claimant. No, the branch manager. Where is that FIR?
17, page 17.
First his signature in claims approval note. So once it is, claim is approved, the money is received. He's forging it. That means like he must be having some kind of connivance with the claimant.
Claim.
Then only they can get some money. Otherwise, the money directly goes to the claimant, right? Check will be issued in the name of claimant.
Claim.
So he will not get it otherwise.
He will not directly get it.
Now, only thing is that like forgery. I mean, like this, whether this signature was, his allegation is that his signature was default. But it says the amount is not settled again.
Not settled. No, because of this discrepancy, dispute arises because of this top matter.
And Lordship would see the FIR for once. FIR said it has been third line, Lordship. It has been brought to my notice that somebody has forced my signature in the claim approval note in setting National Lok Adalat at MSCT Kamrup 1 on 13/9/2025. I have sufficient ground to suspect that Mr. Abhishek Bhattacharjee, working in the same department, has hand in the particular matter. Lordship, there is no direct allegation also. Firstly, it is a suspicion, and I have not done it. What has happened? That he himself has done it. Now there is some discrepancy. Now to save his skin, he has filed this FIR as a compliance. In 32 cases were settled on that day. 31 cases, I have not done it. Why I will do in the 32nd case, Lordship?
Let them go. Let them go. Let them cooperate, and if investigation something comes out, then always we have.
Lordship, 2 times already I have appeared, Lordship. Immediately I appear when called.
You are not in interim, no?
I am in interim.
Both are on interim.
Both are in interim.
I have appeared twice, Lordship. Twice.
So interim absolute. We are into detail. Absolute. Okay, then the first one you take. Heard Mr. N.M. Mohajan. N. Mohajan, the learned counsel appearing for the accused applicant. Also heard Mr. K.K. Parasa, the learned APP for the state. Then you write the decision application, you can take it from here. Then the allegation also you can take it from here. There are 2 and 3. Let this court, a coordinate bench of this court, by its order dated 27/11/2025, has allowed the accused applicant to go on interim bail of rupees 50,000 with a security of like amount with certain conditions stated therein. Full stop. The learned counsel appearing for the accused applicant submits that in terms of the aforesaid interim order, the accused applicant has already appeared before the investigating officer and got his statements recorded.
Yes,
Got his statements recorded. Full stop. The learned APP appearing for the state has also confirmed that the accused applicant has already appeared before the investigating officer. Full stop. In view of the aforesaid, this court is of the considered opinion that the interim order passed on 27/11, interim bail order passed on 27/11/2025 is made absolute in the same conditions that has been stated in the aforesaid order. In view of the aforesaid, the instant bail application, anticipated bail application is disposed of as allowed. Disposed of. Second application also. Mr. B.P. Bora, the learned counsel appearing for the accused applicant. So, para 2 and 3. Then you write the same thing by an interim order dated 28/11/2025. Same order. Disposed of.
Deeply of.
Article
Article, sorry, CD not received.
Here, your lordship, petitioner number 2 is not on interim, your lordship.
Hmm?
Petitioner number 2 is not on interim, your lordship. Petitioner number 1 got the privilege of interim bail, your lordship. He appeared, your lordship.
Petitioner number
1, your lordship.
1 is,
One is the owner of those cattle, your lordship, who has alleged to be stolen and transported illegally, your lordship.
so one is in interim.
Interim, your lordship. He appeared also, your lordship. Petitioner number 2 is here, lordship, that he is the owner of the vehicle which has been used for the transportation, your lordship, that 35 numbers of bulls, your lordship.
So two was not given interim
No,
bail.
lordship, for that reason, your lordship. My humble prayer at this moment, your lordship, because the cattle owner got the privilege of interim bail, your lordship. He appeared also, lordship. He submitted his
So Rosidul Hawk is the owner,
owner of the
vehicle.
vehicle, your lordship. 14 is the registration certificate, your lordship, RC. His name has been reflected, your lordship.
Where is the vehicle now?
Vehicle in the police station itself, your lordship. Because if I got the interim bail, your lordship, then only, your lordship, we can approach for the release of the Jimma petition, your lordship.
35 bulls were carrying in a single vehicle.
Truck, your lordship.
Truck. And because of that, though owner stated that I don't know, but when who were drivers and all this loaded in the truck. CD not available.
Lordship, kindly purchase a seat. I have annexed your lordship. Including typing copy, your lordship. It will start from page number 16, your lordship.
Any documents showing that you have given on rent?
It's not there, your lordship. First, lordship, commercial vehicle, your lordship. So anytime, your lordship, that has been given on rent, your lordship.
No,
Because
any materials showing that you have given on rent?
No, your lordship, but yes, your lordship, I know that those are genuinely purchased, your lordship. For that reason, Your Lordship, I have given my vehicle on ramp. And my learned brother is emphasizing on the cruelty section, Your Lordship, which has been in section 11, Your Lordship, of prevention of cruelty to animals act, Your Lordship. That never impose any, Your Lordship, that impose only fine, Your Lordship. If Your Lordship kindly see section 11, Your Lordship, that punishment part, Your Lordship, 10 rupees, 50 rupees fine, Your Lordship. That cruelty part, Your Lordship. Somebody,
Mr. Porter, let him go on interim bail. And we'll And has he appeared before the police? The
Yes,
other person?
petitioner number 1 appeared, Your Lordship.
We'll dispose even of them.
Regarding Malad, that I cannot confirm Malad because CD is not available.
I mean, then we'll tell them to appear, and in case of non-appearance, then bail will be cancelled. Not Mr. G. Bora, the learned counsel appearing for the accused applicants. Also heard Mr. K. K. Parasu, the learned APP for the state. Then you can write this para 2 and para 3. No, you write para 2, huh? Not 3. Then you write an FIR was lodged on 18/12/2025 25 before the Nelly Police Outpost, Morigaon. Morigaon by 1 ASI Vikas Chandra Das of Nelly OP NELLIE Nelly OP Jagirur PS Morigaon, Assam. Alleging that one vehicle was seized, vehicle was apprehended on receipt of some secret information. One vehicle was intercepted on National Highway 27 at Palahguri, 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 and on checking, 35 numbers of bulls were found loaded in an extremely congested, unsafe and inhumane condition. Full stop. The bulls were seized and the bulls along with the vehicle was seized. On receipt of the FIR, the police registered. Police registered the agreed PS case number 1314/2025 under section 325 in the under the aforementioned sections. Full stop. The learned counsel appearing for the accused applicants submits that the accused applicant number 1 has already been granted interim bail by this court, and thereafter he has appeared before the investigating officer in terms of the order dated 19/1/2026. Full stop. She submits that accused applicant number 2 is the owner of the vehicle which has been seized along with the cattle. However, she submits that that the accused applicant has given the vehicle on rent on a genuine belief that the cattle were being carried in a legal manner. Full stop. She submits that the accused applicant is in fact no way connected to any purchase, sale, or smuggling of cattle. Therefore, she submits that therefore she submits that she will the accused applicant shall fully cooperate with the investigation in the event of the accused applicant is given the protection of pre-arrest bail. Full stop. Next one, the learned APP, Mr. KK Parasar, the learned APP, on the other hand, opposes the bail to petitioner number applicant number 2, no? Opposes the bail to accused applicant number 2. Applicant number 2, full stop. The next one, this court has considered the submissions made by the counsel appearing for the respective parties and has gone through the materials brought on record before this court. After consideration of the submissions and the materials, this court is of the considered opinion that the interim bail so passed in favor of accused applicant number 1 should be made absolute in terms and conditions that has been stated in the order dated 19/1/2026. In respect of applicant number 2, accused applicant number 2, this court is of the view that the accused applicant number 2 should be given the privilege of pre-arrest bail, and accordingly, it is direct that in the event of arrest of the accused applicant number 2, he shall be released on bail on furnishing of bail bond of rupees 30,000 with a surety of like nature with the satisfaction of the arresting authority subject to the following conditions. That the accused applicant number 2 shall shall appear before the investigating officer within a period of 10 days without fail. And then you write that the accused applicant shall cooperate with the investigation and appear before the investigating authority as and when required. The accused applicant shall not try to tamper or hamper with the investigation. That you write, and in view of the aforesaid direction, the instant AB application is disposed of as allowed.
Yes, here this case is wrongly listed as item number 34. It ought to have been listed along with the bail applications. This is regular bail application. They are in custody. Regular bail application. Item 34.
So what is to be done?
Lordship, may I hear me? Otherwise also it is listed. It was fixed today for case diary.
Oh,
Yes, there is come.
no, man. Oh, no. Wrongly.
They have got wrong file.
No, AB started, no? AB 146 edition.
So we'll wait for the case diary.
Lordship, here in this case, already one person is granted bail on 6/2/2026. And my learned friend has brought a different file. Lordship, probably case diary is available in the office. So Lordship.
So we'll fix it. Heard Mr. AK as Mr. A. Ahmed, Mr. A. Ahmed, the learned counsel appearing for the accused applicants, also heard Mr. KK Parasar, learned APP for the state on the prayer of the learned APP that legal matter be fixed on today is,
10th, tomorrow is 11th.
okay, fixed on 11th.
Online.
May it please your lordship. Lordship, in this case, what happened was that there was a bailable warrant of arrest issued against me. Your lordship kindly peruses page 29. The police authorities during the investigation approached the learned jurisdictional magistrate praying for a non-bailable warrant against me, but the learned magistrate, after perusing the case diary, issued a bailable warrant considering my role in the case diary, lordship. But lordship, I did not know that there was a bailable warrant against me, and that was not informed to me. Being a layman, I did not know this, lordship. So I did not appear, and this BWA was converted into an NBWA by the subsequent order, lordship. And that is why now I'm apprehending arrest, lordship. I'm not the main accused. The main two accused persons were arrested and also granted bail, lordship.
But, Malad, when Malad a bailable or non-bailable warrant is there, Malad, like anticipatory bail, Malad, he has to challenge this order will remain. You have to set aside this order, then he has to come under 528, Malad. To quash this order, Malad, non-bailable warrant order, Malad.
It's not a trial, it's a
No.
investigation.
Investigation, of course.
So what was the allegation?
Allegation is that, lordship, there was a there was a Naka checking apparently on the assumption that there was a dacoity going to be committed, and the Naka checking was to intercept our vehicle. Lordship, I did not know, I was assigned the task as a driver, and I did not know that the main accused person is a habitual offender. These facts get reflected. from the-
So the main offender was sitting in your vehicle.
Yes, Lord. No, it is his vehicle. I am the driver. I am the driver.
Yeah, correct. So like you are the driver and like main accused is the owner of the vehicle or what?
Yes, yes, yes,
Hmm?
yes,
He is also traveling with the same vehicle.
yes, Lord.
And you are a habitual offender. What? I mean, that person.
That person.
That
So I did-
habitual offender or what?
different offenses, Lordship, if the Honorable Court peruses the bail order of that particular individual at page number 25.
Page 25.
Yes, Lordship. It is the bail order. There was an objection by the police to his bail where the other cases are referred to. At page 26. This is the main accused person, Mr.
Malad,
Yes.
in the vehicle, Malad, police signal them to, in a Naka checking to stop the vehicle. They hit one police personnel, subsequently that vehicle got injured, and he is the driver. So, Malad, if he is driving the vehicle, this petitioner, on asked by the, Malad, when police asked them
But
to
like now
stop
you have
the Naka checking,
you have a warrant
He-
against you,
Yes, Lordship, NBWA against
NBW against you.
Lordship.
The NBW, if NBW is pending, how this AB will be considered?
It can be, Lordship, there is, if I may read section 420.
Yes, you see it. You'll have to come for cancellation of the NBW. It is to be executed.
Even if there is a warrant, it can be, Lordship. If I may read 428 for me.
428 or
483, Lordship.
482
Lordship.
BNS.
Yes,
BNSS.
NSS, Lord.
$482.
Lordship. There is no bar, Lordship. Because at presently it is pending investigation only, Lordship. It is.
No,
there is
NBW has been issued, man. Investigation, inquiry, whatever, NBW, ultimately NBW has been issued.
That
That order is still there on face of it. 482, let's see, read 482.
Lordship.
Hmm.
when any person has reason
Now, which one, 482?
482 of the BNSS, Lordship.
When any person has reason to believe.
Has reason to believe that he may be arrested on an accusation of having committed a non-bailable offence. He may apply to the High Court or the Court of Session for a direction under this section, and that court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. So the accusation is a non-bailable.
No, that is fine. I mean, like, do you have any judicial pronouncement? See, accusation and like issuance of non-bailable warrant. See, on non-bailable warrant will be issued after consideration of certain material, right? It's not only on mere accusation. So on the basis of certain material, and that is a judicial order has been passed for non-bailable warrant, no, hear me out. Then without cancelling that, how do I give the non-bailable, anticipatory bail to you? Now that, I mean, if you have some judicial pronouncement, you show it to me.
Because otherwise, if I come in 528, there's a bar by the Honorable Supreme Court also that in a
No, you can. No, you did not come here. You can go to that the court where the NBW has been issued. You can always. I think 267 is there. You can file an application for cancellation of the NBW or recalling of the NBW.
But that happens in trial, Lordship, in general course. That happens in trial, that when I do not appear, there is a warrant.
No, not only that. I mean,
Otherwise, in case of granting bail is another thing, but whether in sitting deciding in the case 420
non-bailable warrant was issued for what?
Yes, non-bailable warrant issued.
Because there was because I did not appear in pursuance of a bailable warrant.
Correct. So then you can always go there and like call for, file an application for recall or cancellation of the NBWA, whatever, NBW or bailable warrant, whatever.
Now
Your is NBWA, right?
Yes, because I did not appear
In when the bailable warrant was issued. That's why NBW was issued.
by the NBW.
You can always go there, I think.
But if I go now, then I would be arrested because the NBW is.
No, but there is an order. But see, Mr. Bhattacharya, right?
Day.
Then you come up with something, then we'll take it up. So because you convince me that like if non-bailable warrant is, or you show me some provision that non-bailable warrant is.
Even if there is a warrant by a magistrate, it clearly shows that.
No, where? From where?
Bail can be granted.
No, where?
Section 3, Lordship.
Section 3 of?
482.
482.
Lordship.
Okay, read out.
May I read, Lordship?
Yes.
If such person is thereafter arrested without warrant by an officer in charge of a police station on such accusation and is prepared either at the time of arrest or at any time while in custody of such officer to give bail, he shall be released on bail. This would not apply to me. And if a magistrate taking cognizance of such offence decides that a warrant should be issued in the first instant against that person, he shall issue a bailable warrant in conformity with the direction of the court under subsection 1.
Yes.
So impliedly.
So bailable warrant he should have issued. He has issued bailable warrant. You didn't appear. See, Mr. Day, these are, legal statutory provisions. There are a lot of interpretations in these clauses by the Honorable Supreme Court as well as the High Courts. And like, this court will expect that like, if you come, then like you come with some kind of reading. Correct. So like, you have come here, you have read this clause, then you found this subsection may be favorable to you, you read it out. This is not the way to do it. You prepare. This is a point you are raising. This court is also, asking you that whether there is a provision where the court can grant you. So you try to convince the court to come up with proper,
I was not
preparation.
expecting this argument. That is why I did not prepare.
No. This was a very, Mr. Parasar has very genuinely and like this is the basic. It's a basic.
I will bring more materials.
Now, do you think our PPs are not this thing? Then
I was not expecting the argument.
Then why you not expecting?
That is my.
No, that was a basic thing you should have expected. The NBW has been issued, whether anticipatory bail can be granted or not. That is the basic issue.
I will.
You prepare, come back on the day after tomorrow. Heard Mr. So the learned counsel appearing for the accused applicant also had duty for us learned counsel. Learned APP for the state, Mr. Day request for some time to place some judicial pronouncement in connection with the in connection with his case. Later matter will be listed on 10th, 11th. Let it be on 12th.
Friday.
12th or 13th.
Can it be 12, Lordship?
Let it be on 13th. You come up with something because this court will also require some time to read all those things.
Yeah, please, Your Lord.
Yes, you have
I
got.
would able to bring two order.
Hmm.
One is of 16/4/2006 and 24/2004.
Wherein?
One is not visible, but we can read. It is a declared absconder. He is declared absconder sometime in 2004. Again on 2006, there is an order as the accused person has been declared absconder. This case shall be rest filed till proclamation, till production or appearance of accused.
Okay.
It is there.
Those are readable, no?
Yes, readable.
Okay.
Slightly
Okay.
faded, that is. I'm giving. After 20 years he has been.
You may please serve the copies to the other
I
side
will
also.
serve I will give through WhatsApp message.
You can photo, I mean, like you can probably
The
scan it
extra
and.
copy, if he is available, I will give. Meanwhile, I'll provide it through WhatsApp.
We consider all this and pass in order. Hearing yield. Yes.
This revision petition against the order dated 3/12/2010. My lord, what happened, my lord? The petitioner filed one affair, which was culminated into final report. Then it was converted to complaint case. In the complaint case, my lord, on 2/3/2010, the cognizance was taken against the opposite party. Then, my lord, they preferred a revision petition before the session court. My lord, which is at page 39.
Okay.
My lord, in the revision petition, they filed the revision petition after 127 days. There was delay, my lord, in preferring the revision petition.
So it was rejected or what?
No.
Then?
Then petitioner filed objection.
But how does it matter now? Delay?
My lord, yes, my lord. A long 12 years has gone.
Huh?
A long 12 years
No,
has gone.
that delay is gone now. Now that has been, I mean, was
my
there any order passed by the?
My lord, against the impugn order, the petitioner approached this court, my lord, for rejecting the petition of the objection of the petitioner, man, against that order.
Okay.
My lord, it may be remanded, man. Remanded means substantial time has gone, my lord. But admitted fact, my lord, there was no certified copy of the order dated 2/3/2010, which was challenged in the revision petition before the session court was given, nor a whisper has been made that there was a delay and my lord, the knowledge.
No, where is your this thing? That petition? Objection or your
Yes,
objection?
my objection, my lord. My objection at page 54, annexure 4.
Can you brief me summarily what were the accusations, what was the case? What was the case all about?
My lord, these are the government official, my lord.
Hmm?
All four government official. Government official, my lord.
4 government
They-
officials, yes.
my lord, They came into my property, my lord.
They
And-
came into,
My, they trespass into my property without any order of the court, and they broke one wall. Against that, we have filed.
the government officials means, I mean, GMC, GMDA.
No, my lord, assistant settlement officer, Lat Mondal,
Hmm.
and my lord, Kokrajhar town Mondal,
Hmm.
these are the three persons.
So did 3 persons from the civil authorities,
Yes,
and they went to his property,
yes.
and the allegation is that they trespassed and broke his wall or something like that property. That was the allegation.
That is
Yes,
their
sir.
allegation.
That is their allegation. And you are appearing for the government,
No, I am bearing for this, all these three persons.
those 3 persons are who?
1, 2, and 3.
Hmm.
People Shoikia, Nirmal Nath, and Dipesh Chandra.
And who are they? Who are they?
They are the one, number one is this assistant settlement officer.
That's what I'm saying, the government officers.
Yes, sir. All three.
All three are government officials that you are appearing for. Allegations against you. Now, what has happened to them? They are retired.
No, my lord, they did not, there was they went to measure the land
Hmm.
on the application of the other person, my lord. That's why.
So was there any dispute?
Yes,
Yes,
land
madam.
dispute.
It was a land dispute.
Civil dispute is still going on.
So land dispute. So there was some complaint or application, and on the basis of that, these people went and like they went and broke your thing, broke your wall or whatever.
Yes.
And
They don't-
then
They don't have the right to. break
then you filed an FIR.
File an affair which
And-
has culminated into.
No, the FIR
complaint case-
was,
Complaint case,
huh,
and it was converted into a complaint case.
huh.
And then, my lord, cognizance was taken.
Hmm.
Against the cognizance order, they approached the session court
Hmm.
without filing any condonation petition, without
And session
explaining
court,
any
ses-
delay.
ses-
Against that, I have filed objection.
Ah.
And my objection petition
Was
was
rejected.
rejected. Against that, I have approached your lordship.
Session
This is
court
the,
has-
this is the case, simple case, my lord, already 12, 13 years.
Session
has
court
gone.
has quashed their application, everything.
No, but the, that criminal revision petition is still pending. It's stayed by this one.
No, which is cost?
Their objection,
Our objection.
No, objection is not cost, it's rejected.
rejected.
Yes.
Against that, my friend is here.
Hmm.
And
So
my lord,
their revision petition is pending.
No, correct, that is still better. But you have come against the, I mean,
Against the, that order.
that your rejection of order, your objection.
condonation matter, condonation matter.
And in the criminal.
And my, it is a case of 2011.
Hmm.
Now almost long
15
delay
years.
here. I do not know what is the latest position of this situation.
And
I wrote a letter to them because they are not there. All have retired. They are no longer in service also.
So what is the instructions now? I mean, what, you want to argue this case or what?
my lord,
Yeah, have you taken any instructions from your clients? What is to be done? Now, why didn't you compromise and like finish it off?
My lord, it is, this dispute is not so big, my lord. It could have been compromised, my lord.
No, that's what I'm saying now also. I mean,
Yes.
is there any bar of compromise?
No bar.
No, no bar.
Nothing.
So why didn't you compromise this? Even so many years have passed, only a small issue.
Now what he will get now? Nothing.
No, he's not going to get it, and you also, I mean, unnecessarily.
Now we are the authority on the order of the authority. We have gone there.
Correct. So why didn't you take some, some instructions?
I'll take instruction.
If some instructions, then
Yes.
we'll dispose of this matter.
Yes.
And if you want to go on merits, then we can go in, but I don't think like at this point of time,
My lord, it is,
any
very
fruitful
difficult.
purpose will be
Right.
served
yeah.
with. I mean, some authorities have come, some wall was broken 15 years back. Now probably,
I do not know whether they survive or not.
Yeah, he has no instruction. of
No,
that.
I tried to contact them. Nobody replied me.
so I mean, what is to be done? You tell me. We'll post it some other day, you give.
Naturally.
Let them take instruction on.
Yeah,
I will
but-
also take instruction.
Yeah, both the
But I
parties
don't
taking,
find them, that is the problem.
both the parties take instruction, then we can probably close this. I mean,
Yes, madam.
and hearing this on merit now, again you go back there, again fight there for no purpose at all.
All evidence is also destroyed, my lord, nowadays, by this time.
Heard Mr. G.K. Boyster, the learned counsel appearing for the petitioner, also heard Mr. S.C. Biswas, the learned counsel appearing for the respondents on the joint prayer made by the counsel appearing for the respective parties. Let the matter be posted after two weeks,
Well, 3 weeks, made it.
after 3 weeks.
Obliged.
Obliged. 39.
Yes.
Here some development took place, Lordship. Although there was a stay order that was operating, the charge sheet has been filed. Now, Lordship, I want to file one IA, Lordship, bringing on record that charge sheet. Because there is a judgment I could catch hold of the Honorable Supreme Court, if I may kindly share. Here, Lordship, this Honorable Supreme Court says that if an FIR culminates into charge sheet, in that quashing petition only, the charge sheet can also be challenged, Lordship. So kindly have a look at paragraph number 17, Lordship.
Paragraph?
17, Lordship, 17. Here also, Lordship, I kindly see in paragraph number 2, page 1, Lordship, what has happened? May I kindly read out 2 lines, Lordship?
In a para 2?
No, para 2, yes, Lordship, the first page. During pendency of the appeal in this court.
Where?
Lordship, maybe 1, 2, 3, 4, 5, 6, 7, 8 lines, Lordship.
During pendency of
During
the.
pendency of the appeal in this court, the respondent number 1 filed charge sheet dated so and so in the court of Metropolitan Magistrate Patiala House Court, Delhi, against the appellant herein. Thus, by way of amendment of the main prayer in the appeal, appellants have also prayed for quashing of the charge sheet dated so and so. That
Okay.
was disallowed by the.
Right. Now 17?
Now 17 says it can be done, Lordship. Kindly come. Page number 7, Lordship. May I read out, Lordship?
Nothing on
There
words.
is nothing in the word of this section which restrict the exercise of the power of the court to prevent the abuse of the process of court or miscarriage of justice only to the stage of FIR. It is settled principle of law that the High Court can exercise jurisdiction under section 482 CRPC even when the discharge application is pending with the trial courts. Indeed, it would be a travesty to hold that proceedings initiated against a person can be interfered with at the stage of FIR, but not if it has advanced and the allegation have materialized in the charge sheet. On the contrary, it could be said that the abuse of the process of the caused by the FIR step aggravated if the FIR has been taken from the charge sheet after investigation. Their power is undoubtedly conferred to prevent the abuse of the process of power of any court. So I am here, Lordship, what has actually happened? We challenge the FIR, Lordship.
But it doesn't clearly say so.
It doesn't clearly say so. We have to read paragraph number 2 in consonance with paragraph number.
Not if you read 2 also.
2, what they happen, Lordship, well.
No, this is understood that, I mean, while pendency of the appeal, charge sheet has been filed.
Yes, they amended, Lordship, they made a prayer.
They made a prayer for amendment.
That was disallowed by the High Court.
Disallowed by the High Court.
High Court. They went to Supreme Court. Now Supreme Court says that it can be done.
There is nothing in the words of this section.
Otherwise,
This is
Lordship, here, Lordship, there is no such. If I bring the charge sheet.
So you have challenged, out
I
here
have challenged the FIR.
FIR. So
Now,
now
Lordship-
charge sheet has been filed.
Yes,
So
sir.
your contention is that by way of this judgment of Supreme Court, you can file an additional affidavit and bring on record the charge
has
sheet
been filed.
and challenge this.
Yes, Lord.
Correct. Mr. Borua, do you have any idea?
My brother can have a look also. I can share the judgment with you.
You, both of you look into this.
Because why I'm submitting so, Lordship? Here, Lordship, interim order was passed on 3/5/2018, saying further investigation. During pendency of this further investigation that was stayed, the charge sheet has been filed.
So investigation has been done, that means.
Investigation has been done, although there was a stay. So we filed an IA before this honorable court. IA has been disposed of on the ground that the further proceeding in the court below will be stayed till disposal of this particular criminal petition. But now since charge sheet has been filed, I have to bring that on record, Lordship.
Okay, you can bring that on record and this, yeah, I mean, your contention will be considered. I mean, we'll hear Mr. Borua also on this. Alright.
I
can
share this judgment with my brother.
It will please, yeah. So Mr. Borua, what he is saying is that now, since charge sheet has been filed, they have only challenged the FIR. Now, since charge sheet has been filed, so they are saying they can amend this by way of an additional affidavit
My lord.
and bring on record the charge sheet and challenge that also.
Yes.
That is what he is saying.
My lord. And I have also checked the, my lord, record, my lord.
Hmm.
The case diary, scan copy of the case diary will be required, my lord.
It is before special judge Assam Lordship.
That also may be called for, my lord.
That can be called for because already this honorable court has stayed the further.
It was not called for him so much
My
of
lord,
time.
probably not. I have verified the orders, my lord.
Ah.
That matter has been stayed, my lord. Investigation, FIR has been stayed, my lord. But calling for the record is, I have not found, my lord.
No, calling for the record, that is not their lordship because the IA which we have filed before this honorable court, the IA has been disposed of with the direction that that particular case below will be stayed until and unless disposal of the present criminal petition.
Now, Mr. Borua, I mean, what you are saying is that we need that case diary.
Case diary, scan copy of the record case diary, my lord.
That can be called for.
Because, my lord, he is challenging the search sheet, my lord. Search sheet along with the, my lord, sorry, FIR along with the search sheet.
Charge sheet. Now, he's saying that he's going to bring it on record by way of
Yes, my lord.
affidavit.
That can be, my lord, allowed, my lord.
Now, that we'll see, I mean, whether that can be allowed or not, because this,
Yes, my lord, person to
I mean, that we'll have to see.
I have two prayers. First is to bring the charge sheet on record, it has to be brought on record, lordship. Subsequently, to allow me to challenge the charge sheet.
No,
In
correct,
light
two
of the
things.
judgment that
I
is
mean,
being
if those two things are allowed in a procedure, in this procedure.
Yes,
No,
Lordship.
in
In
this
light of the judgment passed by this Supreme Court in 2016. Paragraph number 17, if your Lordship, it's very clear, Lordship.
No, that's what we need to examine. So we'll go, let us go through this, then we'll see what is to be done. Heard Mr. A. Bhattacharya, the learned counsel appearing for the petitioner, also heard Mr. R.J. Burwa, learned counsel, learned APP for the state. On the state. In the meantime, are you going to file it, affidavit?
Your Lordship allows me. I'll file it.
Or we examine the next day you file?
That can also be done.
Yes,
So Borua, you examine.
Let me go through, my lord, after that.
Because I mean, without, I mean, being convinced that that can be allowed, it may not be right for me to pass that order.
Yes.
On the joint prayer of the council appearing for the parties, let the matter be fixed after.
Next week, my lord, any
Huh?
day. Next week.
Next week we'll do.
18, my lord.
18, some difficulties there, Lordship.
Let it be listed after 2 weeks. Let's see, I'll also
Yes,
see.
yes, my lord.
First week of March, let it come up.
Yes,
Let it be listed in the first week of March. I'll also see.
Yes, my lord.
Interim order passed earlier, may kindly.
Interim order passed earlier, shall continue to the next step of listing.
Diploma.
Learned counsel for the respective number 2 is no.
No, this case has to be disposed of, my lord, because there are sufficient materials, my lord. I have gone to the record, my lord. So let them appear, my lord, because they are also appearing for the informant respondent number 2, my lord. This was, my lord.
This is what matter?
This is a crossing of the, my lord, FIR, my lord.
Okay. So we'll keep
The
it on.
case that you also received, my lord, matter has been stayed, my lord.
So we'll keep it on the next week then.
Next week, my lord.
Next week we'll dispose it of.
Yes, ma'am.
Who is appearing for them?
Already name has already been.
A दोनों का A Ganguly.
Huh?
A Ganguly.
A
Ganguly.
Ganguly. Okay, may I heard you are Mr. Ayuddin.
R. Hawk on behalf of.
R. Hawk, the learned counsel appearing for the petitioner. Also heard Mr. R.J. Boro, learned APE for the state. None appeared for respondent number. Respondent number 2. Let the matter be fixed in the next week. Next week?
Date.
Next week, sometime later.
Obliged.
আসেনি মাঠে
pass over the matter for the day. There is some difficulty.
50, who is appearing? Hmm.
Lordship, my picture.
Some mention was done in the morning or what? Something was told here in the morning. Okay, on the, you're appearing for BM Chaudhary?
On behalf of P. Kotaki.
Okay. A prayer has been made on behalf of Mr. P. Kotaki to adjourn the matter for the day. Let the matter be listed in the next week.
For date may be fixed.
Next week.
In item number 40, Lordship, interim order may be continued.
Interim order so passed earlier, maybe continue until now 40.
Obliged.